our first bill. I want to remind folks on the Education Committee, the House Education Committee, that there are bills being heard in Senate Education as well concurrently. Tomorrow there will be some bills coming up. Bills coming up in Senate Ed tomorrow are 1624, 1671, 1627, and 1135. So look at the Senate calendar. Don't say, well, we're all done and finished here. We may be finished at this level until we get to the next step, but be watching that Senate calendar. In addition, I provided everybody a copy of a report which I asked the department to provide me. It's just kind of a summary of where we are with the CARES Act and all the ESSER 1s, 2, etc., and the American Rescue Plan. That this report's effective March 31, 2022. You didn't get yours, did you, Mark? We can pass one around here. There's one for Representative Hall. So on that, you can look at and see what monies have been allocated to those school districts and to what degree it's been spent already. Information that we want to stay on top of. So today we have 5 bills, and the first bill was supposed to start right at 9 o'clock. That's close enough for House time. We'll start ahead here, and we recognize Representative, not Senator, Senator Ward, if I can get the right day here, for SB 238 relative to special education services in charter public schools. Welcome, Senator Ward.
Thank you, Mr. Chair, and welcome to good morning to all the committee members. This is Senate Bill 238. I move Senate Bill 238 ought to pass with amendment. This bill would require charter public schools to enter into a memorandum of understanding with the resident school district concerning special education service for a chartered public school student with disabilities. MOUs are guiding documents frequently used in local government that clarify the roles and responsibilities of each individual in an MOU. These MOUs would not interfere or undermine any standing contracts already in effect in resident districts. A committee amendment was adopted to require a chartered public school and resident district to review the MOU at least 2 weeks prior to the start of the school year. The Education Committee asks for your support on the motion of ought to pass with amendment on Senate Bill 238. Thank you, Mr. Chair.
Thank you, Senator. Are there any questions of Senator Ward from the committee? Representative Cordelli.
Thank you, Mr. Chair. Thank you, Senator Ward, for bringing this to us. Would there be one blanket MOU between the charter school and the district, or would there be an MOU for each child with a disability in the charter school?
Very good question. I would think that it has to do with each individual because each individual child will have different needs, but it needs to be addressed and shared between the sending district school and the accepting public charter school.
Thank you.
Thank you very much. Are there further questions of Senator Ward? Yes, Representative Woodcock.
Thank you. Good morning, Senator. I'm looking at the last part, lines 50, 16, and 17. And I'm particularly concerned with the notification on 16 and 17 if a youngster with disabilities to receive services. What happens if the 2-week deadline can't be met at that point, right before school opens?
You're looking at the bill amended by the Senate?
I'm looking at the back of the bill that was distributed this morning. I haven't seen, is this?
Line
It talks about the two week period prior to the start of school. If a youngster is, if that MOU or the review doesn't happen in that 2 weeks, what happens?
Could you state that again?
Yes, I'll try to reframe it here. Okay. The lines 16 and 17 are talking about a 2-week review for youngsters with special education plans who are in a charter public school. And it's in the last 2 weeks, 2 weeks before school starts. And my question is, what happens if that doesn't occur during that time frame?
Well, I think that is the reason we have this bill is because that has occurred. So the receiving charter school ends up with a child with disabilities, and they have really not very little, they have very little information on what to do. And I think this bill will put it in writing that they have to meet, they have to have an MOU between the sending school district and the receiving charter school as to the best plan for this particular child. So it has to take place.
Okay, thank you.
Senator Ward, I have one question here. If the MOU is done prior to that meeting or even after it, the language in lines 9 through 11 speak to what the MOU may contain. It may contain services that will be provided where the school district will provide the services directly, and if they're going to do it through a contracted service. If those are usually decisions which are made during the IEP process and written into the IEP. So I would assume then the MOU, and correct me if I'm wrong, please, the MOU is done after the IEP, or you see, I'm a little confused whether it's done prior to or afterwards. If it's afterwards, then this is stuff's already in the IEP. Is the MOU primarily then established for the purpose of notification that we will be having a meeting, and the meeting will be conducted where?
My understanding is that we're talking about a child who has spent time in the public school system and is now moving to a public charter school. So he or she has already had a plan, and that plan needs to be reviewed and discussed with the accepting charter school. So as far as I'm concerned, you can discuss this more than 2 weeks before. If you know that the child is moving over, then anytime you can sit down and talk about it, the better it is.
So a follow-up then, it's my concern though that these types of things are decided at the IEP meeting by all those that are required by law to be there. Then if it's done prior to the IEP, are we then conducting another IEP prior to the IEP?
I can't answer that. I don't know.
Okay, thank you. Representative Luno.
Thank you very much, Mr. Chair, and thank you very much, Senator Ward, for being with us this morning. I see in the bill docket for 238 that there were 3 amendments to it leading up to the bill as amended by the Senate. And I was wondering if you could talk a little bit about the cooperation or collaboration with school administrators and special education administrators in the development of the amendments that lead to the bill that we're seeing today.
There was quite a discussion between the needs of the charter schools, who felt that they were never really told ahead of time, and not enough time for them to plan what kinds of services that the child would need to have. That's why we have at least 2 weeks beforehand. There certainly was input from the school administrators and from special education teachers. And at one point, I know that Senator Khan had talked to the special education teachers, and they essentially said, yeah, 2 weeks is okay, but it would be better to have this conference, this MOU, before, even at 30 days before the school starts. So there were a lot of people involved in the Department of Education as well.
Thank you.
Further questions? Representative Tanner?
Thank you for taking my question. Thank you, Senator Ward. When is a school actually notified that a student has gone to a charter school? So they're a member of the public school, and then they decide sometime to enter a charter school and go through that acceptance process. When do they know, like a month ahead of time before, or do some of them find out like the day of the first day of class. So I'm just wondering how this 2-week period fits with that.
I am assuming, based on my understanding of how these things, that the charter schools will have open, you can apply to the charter school. And if there is a space and you qualify for that space, then they can start, then they can initiate the MOU. Then they know that the child is coming over. I doubt that it happens the day before, unless, I've seen cases where some severely disabled child comes into the public school system and they had not planned for it. And all of a sudden, the second semester, here you have an additional child, which raises a lot of concerns as far as how you pay for it and how you take care of it. So my understanding is that the receiving charter school will know beforehand if the child comes from a public school system.
Further questions? Yes, Representative Cornell.
Thank you. Thank you for taking my question. So then it would be up to the charter school to notify the public school that a student has registered and to get this process going.
That is the way it has been, and I think the charter school would like to know from the sending school that this child is leaving and coming to the charter school. And the charter school can then talk to them and set up a time and discuss, a mutually acceptable time for them to sit down and discuss this child's needs.
Further
Well,
questions? Yes.
Yeah, but I'm assuming that the charter school knows before the public school does that the child is leaving the public school and going to the charter school because they've been accepted. And then the charter school will notify the public school that they need to set up this meeting to do this.
I don't know how that works. I don't know if the public school, if a parent comes and tells it, comes and tells the public school, we're taking our child out and we're going to transfer him or her to this other school. I would think that, I don't think a child shows up in a charter school without having notified the public school because of the education money that is involved. Somebody needs to know pretty early on where this child is going to be the next school year.
Further questions from the committee? Not seeing any. Thank you very much.
Thank you.
Have a good day.
I will.
John, are you here for it? Okay. Next card is Jane Bergeron, New Hampshire Association of Special Ed Administrators. Welcome.
Thank you very much. Good morning. For the record, my name is Jane Bergeron Beaulieu, and I'm the Executive Director of the New Hampshire Association of Special Ed Administrators, here representing over 280 leaders in the field of special education. My testimony is going around. I will keep it short. Our association does see the value of an MOU, but the bill as written raises a lot of questions and needs quite a bit more clarity. The first thing is around some of the conversation that just happened in regards to an MOU being a one-on-one agreement versus an agreement between the district and the charter school in regards to the provision of special education. We were under the impression that this was an MOU that would be an agreement between the two entities. Now it seems as though we're talking one-on-one, which doesn't seem relevant when kids already have an IEP, which covers the specifics of the child. Also, in looking at the bill, there was a lot of questions around this 2-week prior to school starting. Kids enter into charter schools at all time of the year. So a bill that states 2 weeks prior to the start of the school year may not be relevant for many of the children who are enrolling. Also, we'd like to say that, in terms of the LEAs, we fully understand our responsibility in terms of the provision of special education services. And this bill is requiring an MOU, which we wouldn't oppose, but there really isn't any evidence that there's been a pattern of non-compliance in terms of our school districts not adhering to their requirements and their obligation for the provision of special education services to students with disabilities. And so for this reason, we wouldn't really see that this is necessary and would open it up to any of you for questions that you might have for me.
Thank you very much. Are there questions of the special ed administrators? Yes, Representative Cordelli?
Thank you, Mr. Chairman. Thank you for being here. If a child is in a public school and then enrolls in a charter school, there would be an existing IEP. But when they go to the charter school, one of the main issues we've heard from parents is where the services are provided. Now, that wouldn't necessarily be in the IEP unless there's a new IEP at the beginning of the school year. So wouldn't that would be one of the main things that would be covered in the MOU as to where the services are to be provided? Because they're now in a charter school, but the resident district is responsible for the services.
Thank you for the question. That certainly would be a good example of what could be contained in a memorandum of understanding. We wouldn't be opposed to that. I mean, that's something that we talk about with the charter schools and the parents, and that it isn't a part of the IEP.
Representative Woodcock?
Thank you, Chairman Lynn. Good morning, how are you doing?
Good.
Just a quick question. I thank you for speaking, because I was confused as I was reading the MOU, and I asked my associate here 3 times, and she made it more confusing. So I appreciate you clarifying that. I couldn't see a one-on-one or one-on, I didn't understand the concept that. I want to refer back to Representative Cordelli's question, though. Where the services are going to be provided. This says that the DOE will provide a guide, create a guide document. But I thought the services provided would be, if it's going to be one standard template, that wouldn't be there, because every district's going to be different. So I'm not sure how that would work. But in the IEP, am I wrong or do I understand correctly, that when you negotiate the service with the parent and the youngsters in the schools, this service is going to be provided here because that's the only place we have it. The service is going to be provided there, and that's all delineated in the IEP.
In terms of the location,
Yes.
it's the actual service
Right.
itself. So if, they need Orton Gillingham reading and the charter school can't provide that, they decide if the provider is going to go to the school.
Right.
Or if the child is going to go back to the public school. That's all part of
So that
the
service.
conversation, yes.
But that's agreed upon in the IEP when the parents
Yes.
sign off. So I
Yes.
don't understand what the MOU would do to that.
If from my lens, an example would be in an MOU, knowing the schedule, when the service providers are going to show up. So it's not, random and the charter school doesn't get surprised.
Okay.
Or if they're going to leave to go to the public school, that's agreed upon and it's not disruptive to the child. That's a reasonable
Okay.
agreement to have.
All right. Thank you. Thank you, Chairman Ladd.
Thank you. I have a question for you. In the past, we've heard testimony from various folks that it's taking quite a while before the service is delivered to this child at the charter school. For example, a new child that moves in that has multiple handicaps, came in from another state, is now at that charter school. So my concerns go back still to, is this an agreement on a one-on-one regarding each child, or is it an agreement between one organization to another organization, generally how we're going to conduct our relationship here? And it goes into the question regarding contracted services. If it's a one-on-one, I think it's virtually impossible to identify, and I know it says may contain, it's not saying shall contain, but if you're a small district that doesn't have a person that's going to deal with an orthopedic handicap or a traumatic brain injury or a multiple handicap that this child has, then you're going to have to do it probably through a contracted service. But you don't know that until you're in the IEP meeting and you're dealing with it, seeing you've never seen that IEP before. It came in from another state. So how would we respond and how would we work this into a one-on-one between a organization and organization at the beginning year? I think that's virtually impossible to do.
Thank you for the question, and you bring up an important fact that, we're so short-staffed in the state of New Hampshire when it comes to special education service providers. whether it be in our public schools or charter schools. So in some situations, yes, it's very difficult to get those services started on time. I think folks do a really good job of documenting every effort to get those. And to your point about duplication, one-on-one agreements, we're confused about that too, in terms of what that would look like when you already have an IEP, which is basically the legal document. I'm not sure what a one-on-one memorandum of understanding would contain. We've had some really strong conversations with the department, very productive conversations of what might be in an MOU. And I think Becky Fredette could probably expand on that. We've tossed around some reasonable ideas. I'm not quite sure that the Charter School Association is on board with this, and she can probably give you more information about that. But truly an MOU is an agreement between all of the organizations involved, and it's collaborative in nature. And I'm not sure that the charter schools even want this kind of MOU agreement.
Thank you. Are there further questions? Representative Lekes.
I have two questions, if that's okay. One is, when are IEPs usually done?
Every district has a different cycle. Some do them by birth date. Some do them, by the end of the school year. So it's truly left up to the school district and parent. They have to be done every year, but some districts schedule them throughout the school year. Some wait and do them all towards the end of the school year. So it varies.
So, but there normally would be prior to the following year. Is that, am I understanding you right? Like
every
if it's
year.
Yeah, but I mean, like, if it's done, if most of them do it towards the end of the year, that would, then the school the next year would know what was expected at the beginning of the year. Is that am I understanding right?
What the charter school would expect? Is that
No,
what you're-
no, no. If you don't know, let's say you don't know the kids going into the charter school yet, you're in the public school and you do the IEP at the regular IEP time. And then the parent decides that the next year they're going to go to the charter school. Would the IEP normally have already been done?
Again, it's by the district. We have a lot of school districts who are not doing their meetings at the end of the year, just simply because there's a backload and service providers are taken away from kids. So they're trying really hard to stagger them throughout the school year.
Okay. But so
Yeah,
then,
that's how
well,
much-
that was the, I
That's
was
the
just,
first or the second question?
that was the first question. I was trying to make sure I
Okay, let's
understood her
clarify
answer.
the second one.
And
get
the
on with it.
second one is, could the MOU be done at, I mean, if you know the kid is going to the charter school or is in the charter school, could the MOU and the IEP be done at the same meeting? That's my second question.
Again, I'm not sure what a one-on-one MOU would contain. So it's hard to answer that question.
Okay, thank you.
You're welcome.
Are there further questions, Representative Moffett?
Thank you, Ms. Chair, and thank you, Ms. Bergeron, for being here. In your testimony, which I'm reading, you said that your organization would welcome the opportunity to collaborate with DOE and the public charter schools to work on the template and the MOU expectations. So my question is, do you see an opportunity in the short term, given we have a timeline, to perhaps work up an amendment or some language that one of us could submit so that we could discuss an amendment that would be to your liking?
We could certainly go back to our association members and talk with the department about that. But right now, there's so many questions for us that are, not clear. But we could certainly go back and talk with our members.
Thank you.
Thank you.
You're welcome.
Further questions? Not seeing any. Thank you very much, Jane.
Thank you.
We do have Becky here as a technical support. However, Jerry Frew, do you want to, prior to, from the School Administrators Association, then we can have Becky come up from the department if there's tech questions.
Sure, Mr. Chairman. Thank you for the opportunity. My name is Jerry Frew, Associate Executive Director with the School Administrators Association. Nice to see you all again. I won't take a lot of time. I had not prepared to speak at all on this morning because until it was presented, I thought I understood what was being presented, but then there's confusion around. We view the MOU as an organizational document in terms of how organizations are going to interact to provide services to kids. We never saw the MOU as a one-to-one document to begin with. We see that as the IEP, and within the IEP, you identify services that need to be provided, but then the overarching umbrella of the MOU would address how those services would be provided. And so I don't have anything to hand out because we are concerned if the MOU is indeed a one-on-one document. And frankly, I'm a bit surprised that the charter school folks aren't here. I would envision this to be a pretty onerous responsibility on the parts of charter schools. And I think about one where our grandchildren went. I believe that they dealt with 17 different communities, and I can't imagine that they have the bandwidth to deal with perhaps 20 or 30 of their students in over 17 different communities dealing with a one-on-one MOU. I would just, my heart would bleed for what they have to go through. So I think the organizational piece of the MOU is the important part, and that's all that I'll say.
Thank you very much. Are there questions of these? Yes, Representative Luno.
Sure. Thanks very much, Mr. Chair, and thanks very much, Jerry, for being with us this morning. Yeah, I don't see where the one-on-one part is in here, but let's just for the sake of the question, assume that we're talking about an MOU that's between a school district and a charter school, sure. not on a per student basis, but just an agreement. How would this bill do anything beyond what is currently in existing law and referenced in the bill at 194B:11 Roman 3C, which says, and the chartered public school shall cooperate with the child's resident district in the provision of the child's special education and related services?
Thank you for that question, Representative. I do think and we see value in the MOU piece itself because it would offer the opportunity to clearly explain from the get-go who's responsible for what, and it would allow, I believe, the opportunity to address some of the staffing issues in a document where staffing shortages are real. And they're real in our schools. And when a special education teacher leaves partway through the year, and that has happened on a number of occasions, not only does that leave the local resident district in the lurch, but it also leaves the charter school services in the lurch. And so those are real things that are going to happen and perhaps could be addressed in an MOU with a mutual understanding and agreement that if we have a vacancy, XYZ is going to be the process so that the adversarial relationship, between, you have the charter school folks saying, well, we need the services for the kids. And then you have the resident district saying, yes, but we don't have the staff. We've just lost services to our kids as well. At the end of the day, they are all our kids, whether they're charter school or whether they're resident schools. And the imperative is to provide the services. And the MOU is the opportunity to address those issues that may come up and say, okay, this is how we're going to work this out, as opposed to having hard feelings and accusations that, well, you're not, doing X, Y, Z. Well, so I think the MOU is an opportunity, but it's just not ready for prime time, as we've heard say in this body.
Representative Waltz.
What I have is actually more of a comment than a question. And I think one of the confusion here comes from the drafting in the bill. And I want to point out that on line 3, it refers to a student. On line 7, it refers to students, plural, to students. And then down on line 16, it says a student again. So the bill is inconsistent whether we're talking about an individual agreement or overarching agreement for all students. And I just wanted to point that out, that I think that may be where some of the confusion is coming from.
Thank you. Representative Woodcock.
Thank you, Chairman Lay. Good morning. I just want to follow up on your inference about a charter school having multiple school districts. I think you used the term 17 coming to one charter school, which could clearly happen. would it be your understanding in this bill, does that mean there would be 17 different MOUs?
If there were 17 districts, yes.
So they could be particularly, completely different?
And if there were one-on-one
Okay,
students in each of the 17 districts, there
Right.
could be 70 MOUs.
okay. Yeah, thank you.
Thank you.
Jerry, on line 5 through 9, there is a sentence which I think that sentence alone deals with the organizational to organizational units. Talking about cooperating in conjunction with the statute and the types of services for students. If this legislation were boiled down to this particular area, would your organization be in support?
We support the idea of having the agreements and see where that could be valuable, but we need to, it needs to be very clear.
Yeah, thank you. Further questions from the committee? Yes, Representative Luno.
Thank you very much. And I think Chair Ladd's question there, I think was very helpful, as well as your answer, Jerry. Would an MOU that was really specific to be between a district and a charter, not on a student-specific basis, and you suggested that it could address what would happen if staffing changes were made or have happened. Would it also possibly include reimbursement agreement for reimbursement rates and things like that?
Absolutely. I think that's the opportunity that the MOU would provide.
Okay, and it's not on a student-specific basis, but
Correct.
on a more of a school-to-school basis.
Correct.
Becky or for, yeah. Representative Lakis, we do have Becky coming up also.
Okay, so this, we can take input from either one or both of them. I was in rereading it based on the things that you were saying and everybody was saying. It seems to me that the MOU is between the school district and the charter school, but that 2 weeks prior to the charter school, say you have a kid with an IEP that has something that you didn't consider, it says it shall be reviewed to make sure that everybody is covered. So it seems like it's a little of each, that when you have a particular kid, you're going to just review the MOE and make sure this kid's covered by the agreement in case there was something you didn't think of. That's, I guess, my reading of it. I just wondered if you've gone through this, what do you think?
Thank you for the question, Representative. I'm not sure, and I know that legislative intent is a big deal. And given the way this unraveled this morning a little bit, I'm not quite certain what the legislative intent is, and I think that needs to be clarified before this goes any further. That's a perfect question for somebody other than me. Thank you.
Thank you.
Thank you very much. I think what we're going to do now is go to Becky from the department quickly and see if there's any technical questions. Thank you very much, Mr. Frew. Good morning.
Good morning.
It's Monday.
It's Monday. I think that, for the record, my name is Rebecca Fredette. I'm the State Director of Special Education. I think that our understanding of this document was that the MOU would be a one document for each school district that the chartered school works with. I think that when we spoke with both the New Hampshire Association of Special Education Directors and Chartered School Organization, we had discussed how we really needed a clarification of what that cooperation between the two entities would look like. An IEP is going to tell you the frequency, duration, and setting of a service that is provided, but the setting is going to be a regular education setting, a special education setting. So while you may discuss in a meeting that Orton Gillingham is going to be provided back at the regular school, that isn't always what the discussion is in the IEP team meeting. So this would be where you're clarifying that we have 6 students that need Orton Gillingham instruction. It's going to be easier for us to send that instructor to the charter school to provide services than take all of those students back here. So it wasn't intended to be a kind of one-on-one document. It was intended to say overarching, if we look at our 6 students that come to your school, how are we going to work together to get these services in place? Am I going to contract with you? Am I going to contract with somebody else? Am I going to send my own person from my own district to come do these services? So it was really those logistics, because that was what we had heard was the concern. There wasn't the concern with the IEP or what the services were stated in the IEP. There was the concern of how those logistics were kind of figured out and determined between the school district and the chartered organization, because we found many times there was a different interpretation of what had been discussed. And so this was kind of putting it into a document and saying clearly, this is what your responsibility is, this is what your responsibility is, so that there was no misunderstanding 3-6 months down the road when one entity received a bill from the other one, or one entity asked for payment for something else. It was to very clearly state, this is what you have said you're going to do, this is what you have said you're going to do.
Thank you. Are there questions? Representative Porter?
Thank you, Mr. Chair. I don't know if you're the right person to ask this, but my mind has been trying to get around the fact that a charter school might have kids from 17 different districts. And so 17 different districts will be providing special education services to the children at the charter school. In my experience in the classroom of the regular public school, when there were a group of children who had the same sort of needs, the group would meet because of staffing and needing to be efficient. So all 5 kids from 5 different classrooms would all go to the special ed room and get the service that they need. In the charter school with 17 different districts, if there are 17 kids all with the same special ed need, do they all get serviced by their individual district then, or?
That's what that MOU would clarify. So if you, with that scenario, if you had 17 students who needed Orton Gillingham instruction, I'm just going to keep building off of Jane's conversation, and they needed Orton Gillingham instruction, the charter school could say, I have 2 from you and 2 from you and 2 from you. We're willing to, if you can all contribute, we're willing to hire a teacher to teach those 17 students, so that I'm not having you send somebody and I'm having you pay for something and I'm having you take the kids back to your school. We're trying to make that agreement so that it's easier to say, you all need this, I'll agree with you to do this. And there may be some nuances though, if you have a student who has a one-on-one in one district, but maybe not in another district. So it's clarifying those, but it would give them the opportunity to also say, we can do this because we have all of these students that need that same service.
Thank you.
Representative Ellison?
Thank you, Mr. Chair. Thanks for taking my question. Building on the examples we're using, with 17 school districts sending students to a charter school, even if it's an agreement between the district and the charter school, we're talking about 17 separate agreements. Is that
Yep.
correct?
Yes, but it wouldn't be it would be less than if you took all 30 kids that came from those 17 schools and wrote 30 individual MOUs. So that was why we did. That's another thing, is it's only going to be for the district. They already have to cooperate with that district and they're already making these agreements. So it's just putting it into a document.
Follow up?
Quick follow-up. So actually, the number of MOUs that would be in place is determined by the number of school districts sending students to that charter school.
Yes.
They could be getting students from 25 districts. There had to be 25 MOUs at that point. Is that
The
correct?
highest I've heard is 14 or 17. So, but yes, it could.
Thank you.
Representative Tanner?
Thank you, and thank you for taking my question. My question is about the guide that the DOE is supposed to develop and provide. Could you tell me, kind of explain to me a little bit about how that guide is going to be developed and what exactly might be in that? Is it kind of open-ended questions, or is it prescriptive?
So we would want to collaborate with both the charter schools and most likely the Association of Special Ed Directors to ensure that we're getting some clear questions in there, but it really would state where services are going to be provided for the students. So is it going to be that the students are at the charter school or that the students are going back to the resident district. Who's paying for portions of those? If you agree that the child is going to receive the services there, are you then contracting with that chartered school to pay them a portion of that? So really just clarify those details of how you're cooperating. Yes, we're going to send the students there. Yes, we're going to pay you for this, any of those details that may not be worked out in your IEP team meeting.
Yes.
Thank you. And how is that mediated? If there's like strong disagreement, which we've heard in the past between the charter school and the sending district?
That's a good question. There's no mechanism for a mediation of that. The district is responsible for those services, so they need to be able to determine how they're going to provide those services. They could always ask for our support, but it's not something that we would. I mean, ultimately they have to provide the services. This is just how are you going to provide them?
Thank you. Further questions from the committee? Not seeing it. Thank you very much.
You're welcome.
I do not have any other pink cards on this. Oh. From the School Boards Association.
I apologize. I was not going to speak on this, but there's a few things I'd like to just offer the committee. For the record, Becky Wilson from the Hampshire School Boards Association. I would agree with the previous speakers that when this bill was originally discussed in Senate Education, I think the majority of people felt the MOU was really a district and charter school level document. Different districts have different resources, different charter schools have different resources. In our minds, the MOU is really about global decision making in terms of who is responsible for what decisions between the charter school and the local district. From a more of a school board perspective and more of a management, things like who's hiring the staff, who's responsible for hiring certain staff, who's responsible for supervising that staff member if they are a district employee versus a charter school employee, who's setting the rate. I think that was brought up previously. What's the collaboration between the public charter school and the local district in terms of supervision of the staff, evaluation, and to just try to clarify and limit confusion between charter schools and local districts about decision-making authority. In our minds, the IEP team is the one that is making the decisions for student level decision-making, where services are going to be provided, what are the services, what needs to be translated from when the student was in the local public school to the charter school, how might things look different. Those are all IEP team decisions, and the IEP team is required to meet when the student enrolls at the public charter school. There was also some discussion previously about you may have students at public charter schools who do not require special ed services. So not every school district is going to automatically have an MOU with every public charter school. You're only going to enter into this once you know that you have a student who has enrolled in the public charter school. That may not be prior to the start of the school year. While that's ideal, I think for most people, that's not always the case. There are students that move during the school year or enroll over time. And there was quite a bit of discussion about this 2 weeks prior to the school year requirement, that if it's going to be between the district staff, for example, the special education director or the superintendent and the administrator at the local public charter school, those people are available over the summer. But if there's some expectation that there's other people involved, not all of those people are available prior to the school year starting. And not all of those decisions, at the student level necessarily are going to be made prior to the start of the school year. So I just wanted to clarify that from the school board's perspective, we're seeing this as a very similar to other MOUs that you might have, for example, with the police department, if you have a school resource officer, about who's doing what, who's responsible for what decisions, who makes the final call, etc. So I'm happy to take any questions.
Thank you very much. Are there any questions, Representative Moffett?
Thank you, Mr. Chair. Thank you, Ms. Whitley, for being here. And this is a question that perhaps might have been better addressed to the previous speaker, but let me ask you. Schools, especially charter schools, have finite capacities. So my question has to do with the discretion that charter schools have in terms of accepting numbers or certain students. Can can public charter schools opt to just not accept certain special needs students, or can you speak to that?
Thank you for the question. You certainly could ask that of the department as well, but they are public schools. They are required to look at all students who want to enroll there, and the IEP team is required to meet once the student enrolls there to talk about what accommodations and modifications the student would need to be able to participate.
Thank you.
You're welcome.
Representative Mullen?
Thank you, Mr. Chair, and thank you for taking my question over there, Ms.
welcome.
Wilson. My question is about whether or not in your review of MOUs, because I would imagine your agency sees a fair number of them, are there ever provisions in the MOU to evaluate the effectiveness of the MOU?
Thank you for the question. There typically are timelines built in to review the MOU and to ensure that it's, meeting the needs of both parties. I think that is where we feel that the model from the department would be helpful. I think both for local charter schools who are going to have a number of districts, and if this were to pass, in terms of trying to negotiate these multiple MOUs. But again, to your point, I think to Representative Moffat's point, different districts and different charter schools have different resources. So the specifics of what might need to be contained in each MOU might be a little bit different. So it would be important to review those on a regular basis. I think once you have a student enrolled in the public charter school who requires special education services and you have an MOU, it would make sense that you would review it on a regular basis. But again, that doesn't change the fact that if you were to have one student with special education needs who enrolls in the local public charter school and you develop an MOU, you're reviewing that child's IEP as an IEP team. If another student from your district enrolls in that same charter school, you're not necessarily doing a new MOU, you already have that, but you are having another IEP team meeting for that particular student to talk about that particular student's needs and how those are going to be met in the public charter school.
Thank you. Are there any further questions of Becky? Not seeing. Thank you very much. And with that, I have no further cards for this bill, so we will close this hearing for 238 and move on to the next hearing, which is SB 381. This is a bill establishing the Office of Advocate for Special Education. And Senator Reagan, who's been waiting so patiently here, is here to present the bill. Welcome.
Good morning, Chairman Ladd and House Education. Just as a note on your last bill, I served on a commission that investigated the effectiveness of these agreements between the school districts and the charter schools. And it was very encouraging to see how well all these adults got together and worked out problems with transportation and do we hire a teacher or do we share a teacher? And so all that was very encouraging until you people last year passed a bill that said we're going to change who's responsible for who's bears the responsibility for children with special needs. And in this room, we investigated that. And we heard from a lot of people, and we produced a 4-inch binder of testimony, and there wasn't a happy story in the whole binder. So the binder's at the Office of Performance Audit and Oversight now, and they're developing a scope statement for a performance audit of how we're doing with special education in the state. And that brings me to Senate Bill 381. And I'm Senator John Reagan from Senate District 17. And I'm quite happy to present Senate Bill 3812.
May I add one thing in, please, Senator? For the committee, this is an early bill. This bill has to be out of this committee this week. Go ahead.
Okay. So, this bill establishes an Office of the Advocate for Special Education. The way is cleared to implement this office. And there's a lot of discussion about why somebody else isn't advocating for special education students. But there are a lot of people who are charged with that responsibility. But pages and pages of testimony from very upset parents of special education students tells us that we had to go somewhere else. So what the study committee did was decided to ask for a performance audit of special education because we couldn't get answers, and left us with the idea for the special advocate. So that's, as that previous school board fella said, what's the intent of the legislation? So the intent of this legislation is to have somebody fielding the problems that are presented and often defeated by law firms in the state of New Hampshire that have made it their business to defeat the parents of the special education students. So one pair of parents have in several years paid over $23,000 in tuition, and they drive their daughter an hour each way every day to get to a school that is meeting her needs. So that was an expensive solution to the problem. And then we listened to a lot of parents that were often in tears over what they had to say about the treatment that they had developing an IEP and having been browbeaten by a law firm and finally giving up. So that's pretty tough when we have a pile of statutes, federal and state, that say you have to do something. You can't just abandon these children. And that's pretty much how the system works now. If they're too costly or too much trouble, or the parents aren't able to employ an attorney to come to the meeting, they're just beaten down and they're not able to help their children. But it's the law. We have to help their children. And I facetiously said at one point, why don't we just take these kids and we'll just build another building out by the state prison and we'll just put them in there, and then we won't have to worry about them. They'll be fed, clothed, they'll be housed, and this is where they'll spend the rest of their lives. And I had too many people said, you're right. This is the solution. If you're not going to help them, you might as well put them somewhere where they're safe and other people can be safe from them, because they're going to too often turn to crime for a way to make a living, because we're not giving them the tools that we all enjoy because of this faulty system. So I appreciate what all the well-meaning people in this business say they're doing, but we've just got too many lost children. And that's what the Office of the Advocate for Special Education is designed to do.
Thank you very much, Senator. I have one question for you. We've received correspondence from the Office of Child Advocate.
Yes.
Which is a independent agency within the Department of Administrative Services, indicating that this bill replicates duties that's their responsibility that they are performing. Do you see it the same way?
No, because we had no testimony that anybody was assisted by the Office of the Child Advocate for Special Education Problems. And that was my answer to the former child advocate who decided it would be a good idea to take this office and give the money to the Office of the Child Advocate and let them have the employees and continue on their not so successful mission.
Thank you. Are there questions from the committee? Representative Luno?
Sure. Thank you very much, Mr. Chair. Thank you very much, Senator Reagan, for bringing this forward. Towards the conclusion of your remarks, you talked about special education students that had been abandoned by their district, and that's a pretty strong statement. I was wondering if you could elaborate on that, not getting into specific names or specific districts, but just in your selection of the word abandoned, you provide a little context for that.
Well, the context would be that the parents, knowing their child has a problem, and then goes to the school and say, I understand their services for special needs children. And then they then proceed through the process that exists now. And in the end, there's nothing available for their children.
Yes.
And thanks. I certainly recognize. I mean, I think a number of us have been on school boards, and recognize that yeah, parents are certainly very connected and engaged to advocate for their children, and that sometimes disagreements do arise between a school.
I'm sorry, but I don't have the binder that has all the testimony. And those are very specific examples. Representative Mullen, Cordelli, and Ladd were the other members of the study committee.
Thank you.
Further questions for Senator Reagan? Representative Woodcock.
Thank you, Representative Cordelli. Good morning. Thank you for taking my question. I read through this a couple of times. I'm just trying to find, beyond the annual report and the annual information and the metrics, what is this person's actual power to change something?
The setup is that the advocate will collect all the information of everything that's going on and become the expert opinion on behalf of the children.
Follow up, Mr. Chairman? Thank you. Okay, so they advocate, what is it they can actually do to change something?
I imagine we'll see reports coming out of courtrooms over what they're going to have to do on behalf of the children.
Okay, thank you. Thank you, Mr. Chairman.
Thank you very much, Mr. Chair. Thank you, Senator, for taking my question. Can you explain to me who this advocate will report to?
It's an independent office, much like the Child Advocate Office was created. So
I do. I have a follow-up. Thank you. So they will be paid, that office will be paid out of taxpayer funds, correct?
correct.
Thank you.
You're welcome. Representative Lekis?
So do you see this predominantly when a parent takes a school district to court, or do you see them acting before that time with the school district?
Hopefully we'll learn where the pitfalls are that don't allow the special needs children to receive services. So this is a information gathering mission for the advocate.
Thank you.
Further question, Representative Mullen. And then Representative Waltz.
Thank you, Mr. Chair, and thank you, Senator, for taking my question. In the actual hiring process, the bill indicates that the governor and council would appoint somebody to this position. And it references experiences and qualifications that would make them appropriate for the job. Can you elaborate a little bit more on what those experiences and qualifications might look like?
I'm going to cede that idea and specification to the governor and council. They're going to have to decide where to find the best person for this job.
Further, Representative Waltz.
Thank you, Mr. Chairman. So I used to work for the U.S. Department of Education Office of Civil Rights. And people all over the country who thought that their kids were not getting a free, appropriate public education, these are parents of special ed students, could and did complain to, and I'm sure continue to complain to the Office for Civil Rights. And it was a huge deal to investigate those things. I mean, we had there's 10 regional offices. There were huge staffs that went in. You'd send a whole team of investigators in to do this. This was no simple thing to determine whether a school district was providing the most an appropriate education to a special ed child. And it appears that this office is set up to address concerns of individual parents, not just look at for patterns in school districts of not providing FAPE. And I'm concerned as to how this could possibly work and not just become a place where every disgruntled parent in the state goes and makes a complaint, whether the school district is at fault or not, and how this office at a budget of $500,000 could possibly have the resources to deal with the number of disgruntled parents in this state.
Well, if you wanted to amend it to add money.
Senator, I also serve on finance. I know more than that.
As do I.
Further questions from the committee? Thank you very much, Senator. I'd like to invite Cassandra Sanchez from the Office of the Child Advocate.
Good
morning.
morning. Good morning, Chairman Ladd. I have copies of my written testimony, if that's necessary.
Do you have multiple copies?
Yes, I
there?
do.
Sure. Why don't you just hand them out to Representative Ford right there, and he'll take care of it.
So thank you for this opportunity to meet with you all, and I hope that we'll work together more in the future. I was just confirmed to this position last week, so I'm brand new here. I've also brought with me Emily Lawrence from the office to help with answering questions. I do rely upon my full written testimony as submitted, but I will share some highlighted points in the interest of time. As you know, the Office of the Child Advocate is an independent agency mandated to provide oversight to state and state-arranged services to children and promote children's best interest. I am here today to speak in opposition to Senate Bill 381, establishing an Office of the Advocate for Special Education as written, but would support the concept in an amended version. Senate Bill 381 would establish an independent agency administratively attached to the Department of Administrative Services to house an advocate for special education. The bill replicates current obligations of the Office of the Child Advocate. We do recognize the need for this role, but believe there is a solution without redundancy and extra cost. The Child Advocate already has jurisdiction over education and special education with access to children's educational records and other information about children pursuant to RSA 21V. While I am only days into my role as Child Advocate, my understanding is that the mandate over education is relatively new and that the office has not yet fully mobilized to educate the public, including the legislature, about our expanded jurisdiction. We also lack the level of expertise that Senate Bill 381 represents in a new agency. We know that parents struggle to obtain needed special education services for their children, and we are grateful for all those parents here today and to every day advocate for their children, as well as Senator Regan and the bill's co-sponsors for recognizing the needs for many children and families. Too often, the very manifestation of a child's special education qualifying disability that has not been properly assessed or addressed is the cause for behavior that prompts out-of-home placements or adjudication for delinquency. Enhancing resources to assist children to access special education services is in the best interest of children and their optimal development. It is also in the state's interest to reduce unnecessary spending on children receiving expensive, deep-ended services such as institutional care because of unmet educational needs. In the Senate Committee of Cognizance, we pointed out the redundancy of legislation and recommended Senate Bill 381 be amended to place the Advocate for Special Education in the independent office of the Child Advocate. The primary reason for this is the office's jurisdiction over special education under RSA 21V. We recognize that we have not yet fully engaged individuals regarding assistance with special education concerns. This shortcoming is viewed as an effect of limited staffing and pandemic-related obstacles for community outreach. We further note that in the Senate Education Committee hearing, Rebecca Fredette, Director of Special Education with the Department of Education, testified that the bill is redundant to some of the functions the DOE is required to perform per federal law. She explained that since she has been in the role for only a short time, she is working to ensure that the system and services are being more responsive to families. Placing the Special Education Advocate in the Office of the Child Advocate would bring that expertise and extra manpower to provide outreach to families and effective advocacy specific to special education when needed. Many children with complex special education needs have other needs served by multiple systems, such as developmental disabilities and behavioral health services, and juvenile justice or child protective services. To that end, the Office of the Child Advocate is already working with many of the same families that would benefit from a special education advocate. Keeping all advocates under one roof would situate the special education advocate with in-house supports and expertise in those other specialty areas. Creating a whole new agency would be confusing for families already navigating a complicated system. A single access for assistance navigating systems and advocating for children eases the burden of already frustrated parents. Ultimately, keeping to one Office of the Child Advocate would save the state considerable funds. As requested of the Senate Education Committee, I have provided very basic overhead costs of a new agency versus enhancing the Office of the Child Advocate with extra staff. They represent a potential savings of approximately $317,000 from the bill's fiscal note of $500,000. This estimate does not include cost and workload burden for the Department of Administrative Services, who staff administer services for administratively attached agencies. Recognizing the need to follow the field toward more prevention services to minimize child protection and juvenile justice cases, the office's jurisdiction was expanded to all children's services. This expansion of services is just over a year old. It is very timely that Senate Bill 381 was raised, as the need for the specialized resource is recognized in the Office of the Child Advocate. For these reasons, I urge you to amend Senate Bill 381 and place the Special Education Advocate in the Office of the Child Advocate with an allocation of funds for the position and one legal aid to support the advocate. Thank you for your time.
Thank
and
you
I
very
welcome any
much.
questions.
I do have one question, a sort of follow-up to your presentation. I received the email from you the other day, and in it says, we also lack the resident expertise in special education law that would be most helpful to children with complex needs. So the letter itself stating that you don't have the expertise in this area of special education law, then why is your organization then oppositional to the direction of this bill?
Correct. We do not, which is why we believe taking on the staff who have that specialty to work alongside the other advocates within the office would be a better option as opposed to a separate agency in itself.
Thank you. Questions from the committee? Representative Luno, then Representative Lekis.
Thank you very much, Mr. Chair, and thank you very much, and congratulations on your new role here in New Hampshire.
Thank you.
I was wondering, and sort of follow on to what Representative Ladd was inquiring. You talk about the sort of the multiple dimensions of the Office of the Child Advocate, and certainly having to work with a number of different parameters and the sort of I guess the specific needs of different children, and the different support channels that exist in the state. would incorporating special education under the Office of the Child Advocate improve the outcomes, not just for special where there's disagreements with respect to special education, but also perhaps for other children too, by having that expertise, under one roof?
Yes, we do believe so, because we do have the expertise in regards to children with mental health difficulties and behavioral health struggles. So incorporating the special education, which is often a crossover with where we see a lot of behavioral needs, having that all in one house and sharing the expertise with the person who will bring in an expertise in special education would optimize our ability to serve all families.
Thank you. Representative Lekis?
Thank you. I'm just trying to think about how this works. Can you tell me if a parent, or well, let's say if a child needs an advocate, who pays for the advocate?
Meaning in working with our office?
Whether it's, whether it's whether it will be the special needs advocate or whoever, an advocate that's assigned to the child, who pays that? Does the state? Does the parent? Who does?
So within our agency, we have staff that are paid through the state, and those staff screen calls, handle complaints, and they would be, in this case also, having the special education advocate along with a legal aid would be able to be the contact paid through the state with the budget proposed.
Thank you.
Further questions from the committee? Representative Cordelli?
Thank you, Mr. Chairman. Thank you for being here, and congratulations on the new position. Welcome to New Hampshire.
Thank you.
Just wondering about your statement about approximately a year ago, there was a mandate expansion for to include education, and looking at the statute, I really see that it looks like the current responsibilities of the office are centered on child welfare and juvenile justice. So maybe a little confused about where the education responsibility comes in.
Absolutely. So with that expansion, we were able to have oversight of all agencies that service children across the state, which would encompass education as well. So we have access to the records and the ability to communicate with schools on behalf of children.
Further questions? Yes, Representative Ellison?
Thank you, Mr. Chair. Thanks for taking my question. Just maybe some details from you on how this person, the advocate, would function, going back to the previous discussion about who are they responsible to, what is the outcome of, let's say they'll deal with a number of cases, they decide that this has happened, this has happened, this has happened. What effect is of that information? I'm actually asking, what is the impact of what this person could actually do within the systems?
Sure. Much like the Office of the Child Advocate, within our office, they would fit in a similar role with the ability to collect the data, process the data, work on complaints with families, and then take this back to meetings with the Special Educations Department, meetings with legislature about other legislation that impacts special education for children. So they would have a very similar role to mine now, but specific to special education.
Thank you.
Thank you. Representative Porter?
Thank you, Mr. Chair, and welcome.
Thank you.
So I'm a little confused about the word advocate. In my mind, if I were a parent and I had a child with learning disabilities and I felt that they weren't getting what they needed, and an advocate came to help me, I would think that advocate might be coming to the IEP meetings with me and helping me understand the law and that sort of thing. But I'm getting the idea from what I'm hearing now that that's not what the office would do. The office would be more checking into things and making reports so that things could get fixed. Am I right in my second
Yes, we would not have the resources to have staff attending all IEP meetings. We would be able to help educate parents on rights and how to proceed. And we would also be able to point them in the direction of other resources that already exist within special education that they may not be aware of that could help on more of that direct level. Yes.
Representative Tanner?
Thank you. Thank you for taking my question. So does the advocate then become an expert witness and, or give the parent legal advice or information that they can then bring to any kind of adjudication of their concerns?
I don't believe so, because currently with under the child advocate law, it does not state that we can be involved in any court involvement. Being an expert witness is not included in the role, so no. Thank you for your question.
Further questions from the committee? Representative Hall?
Thank you, Mr. Chairman, and thank you for taking my question. What I gather, the Parent Information Center pick that the parents use, do they pay for that service, do you know, that the child advocate? Are you familiar with the Parent Information
I
Center?
do not know.
Okay.
Emily Lawrence, I'm the Associate Child Advocate. And are you asking if the parents pay for that service?
Yes. Do they have to pay, when they want an advocate and they go to the Parent Information Center, is that something they personally are responsible for paying? Or is it free?
Not something I'm entirely clear on, but I believe there is federal funding for some of that.
Okay.
So I think some of it is covered. But I can get back to you with an answer on that for sure.
Okay, great. Thank you.
Yeah, we have to make sure people are using the mic when they speak.
Oh, I'm sorry.
Are there further questions? Representative Moffett?
Thank you, Mr. Chair. Thank you for being here. Welcome aboard. Quickly, I certainly, you got our attention when you mentioned the $317,000 savings, but again, this is a policy committee, so back to policy, and I know you're new, but perhaps somebody, I know Representative Mullen, Representative Cordelli, Representative Latta, and Senator Reagan have already dealt with this. My question is, are you aware of success or not success with this type of position in other states? Are there models out there that we could look at?
I'm not familiar with the specific special education advocate utilized in other states. I am aware of other states, like our proposition here, choosing to have a specialist within the Office of the Child Advocate that assists with special education needs.
Quick so what you just said then is the notion of this position being rolled into an existing position, that model is out there in other states, is what I'm hearing.
Yes.
Oh, okay, thank you.
Further question, Representative Hobson?
Thank you, Mr. Chair, and welcome to New Hampshire. Thank you for taking my question. I was just wondering if, I don't know if I missed it, your letter was pretty information packed. Can you tell me, do you know how many positions you might be looking to hire? Thank you.
Yes, so we would be looking for two positions, one being the special education advocate and the other being a legal aid to assist with the advocate's role.
Further questions? Not, yes, Representative Ford.
Thank you, Mr. Chair. Thank you for taking my question. Several times as we've talked about these kinds of issues, we've gotten to this point where we've been talking about someone gathering information. And perhaps you heard just a little bit before when people got a little frustrated because they were looking for an answer from the senator. And I suspect the same is from you, but I'd like you to confirm or deny that. What happens when you get to a point where you're aware of something which might even be illegal? What then do you do? And that's what we're not hearing with this. It's just sort of, well, we know about it. Well, we're more interested in what are you going to do about it? Or what are you authorized to do about it? And if it's not anything, I understand that, but we need to know that.
Absolutely. So what we would look to do with this role is we would look to collect the data, like I said, follow the trends, put out reports on this so that it is aware. We'd look to have connection meetings with the special education department on a consistent basis to talk about these issues, to talk about resolutions to these issues. We could make recommendations for solutions once we have some data and some reviews. and then also bring things to the legislative table if we feel that they, advocate for change, if we feel it's not being addressed at the special education level. And we have the data then to back what we would look to change in legislature.
Thank you. Further questions of the Office of, oh, yes, go ahead, Representative Luno.
Yeah, thank you very much, Mr. Chair. And thanks for taking my question. Would, just sort of following on the conversation about, folding this in underneath the Office of the Child Advocate, given your existing expanded authority, would this need to be done, this being the ability to hire a special education advocate and the legal support staff under the Office of Child Advocate? Would this need new legislation, or could this be done through, let's say, the budget process?
Thank you for the question. I believe this could be done through the budget process since we already have jurisdiction over this area. It would be a matter of just folding in these new positions.
Thank you.
Further questions? I have one follow-up. I've worked with this office before when we're talking about individuals which are incarcerated in one of the institutions we have here within the state up in Grafton County, where a person was under age 21, had an active IEP, and was not being served. In terms of, though, of regular education, does your office have authority to access educational records of any student, or do you have to be first contacted to have that right to access records?
So under the statute, it allows us to access, it says education records. So typically we wouldn't just access a record unless someone contacts us, but we don't necessarily need to, under the law, we have that permission to access.
I'm
that
familiar with that area of
Yeah.
statute. I was just curious to know how that worked, though, in terms of saying, I want to go and look at this file, this student. Can you
Sure.
do that without parental permission?
Sure. We currently can with DCYF records. To be honest, we have not had the opportunity to go look at case records specifically at a school, but it is our understanding that we would be able to do so. And we do not have to seek permission, for example, with the same with DCYF.
Thank you. Representative Mullen?
Thank you, Mr. Chair, and thank you for taking my question. I'm going to ask you the same question that I asked Senator Reagan. If you were to be hiring for this position, how would you go about, or what kind of criteria would you use to determine who has appropriate experience and qualifications?
Yes. So we would be looking for somebody who has a background in special education for a specific length of time, but especially if they have had the opportunity to be on the advocacy end, whether previously enrolled as an advocate or having actually done the frontline work of advocating. So we would be looking for that background, and we would also use the assistance of our oversight commission in that hiring process.
Are there further questions? Thank you very much.
Thank you.
I'd like to call forward Kate Shea.
Good morning, committee. Kate Shea, Goffstown. Thank you for hearing me, Chairman and esteemed committee. I just wanted to say a few words this morning. I'm here representing families of New Hampshire. And I'm going to keep this short as I have to run to another meeting. I'm one of your typical special needs parents that's trying to fit in everything for my kids and to advocate for them, including being here today, because not that it affects them directly anymore. I think I shared with the committee last time I was here, 3 of them are now out of school doing other alternative school options. And, I think there's a few different arguments I want to cover. One is, I think we want kids in school, right? I think we can all agree to that. We want kids in school being part of the system, getting the supports and services that they need, right? And the people of New Hampshire spoke really clearly on this bill several months ago, maybe even a year ago. 700 people signed a petition for this bill and felt it was that important. And I have to tell you, having advocated for families in the state now because of my kids, that it's a very precarious position you put yourself in when you stick your neck out and you sign a petition like that. it comes with retaliation. That might blow some people's minds, but that's the life that we live when our kids are in special education in this state. We are regularly retaliated against. And we had people, 700 people sign this, put their names to it. So I would multiply that many times over when you're considering the amount of family need for this. What I didn't hear with the last couple of speakers was going back to why we're here. We felt that an independent party, boy, and that word really rings and means a lot to me. Independent party was needed for this role. Why would that be? Well, I heard grow resources, work with special educators, redundancy, jurisdiction, lacking, pandemic. Where are families in all of this? That's one thing that really jumped out. I didn't hear anything about families. I am the voice of the families, and I sit here and I imagine a slew of, army of parents behind me when I come to speak, because I fit it in between the little time that I have. And I hope that that carries a lot of weight, because I do feel it's important to be here and to say we're leaving families out of the equation. We don't need another PIC. We don't need another disability rights center. We've had these solutions. We've tried them. They don't work because 381 said that they didn't work, right? So if we want kids in schools, then we need to look what services they need in the eye and provide FAPE, which is, according to federal law, a free and appropriate education. We are not doing that in the state today. So to talk about funding and we'd need more money and, gosh, if we get a class action lawsuit, all this goes out the window, okay? Texas had that happen. I'd hate to see that happen here, but that snowball has been building over time, and it will eventually happen if we don't address this in the right way. So when I hear about another agency or another group that's going to grow itself, first of all, there's a lacking level of expertise here that stood out to me. When you're talking about the Office of the Child Advocate, and I can tell you this from firsthand experience, I came through a 6-year marathon divorce in the great state of New Hampshire, and I paid for a guardian ad litem. I figured they would understand special needs. We're not talking anything too rocket sciencey here. We're talking about autism, things like that. Do you know that in the final report, not any of the plethora of evidence that I provided from medical doctors in Boston was taken into any consideration? And that's just one experience of many where this happens all the time. We're not talking about kids that need residential or institutional care. We're talking about your average child that now about 1 in 20 has neurodiversity and neurodiverse needs. The rigid school settings aren't a good match for that. So we're talking about 30 minutes of speech, 30 minutes of occupational therapy a week, something very basic. And I also heard this group isn't going to be in IEP meetings. So if you're not even going to be in IEP meetings, how are you possibly going to understand what's going on in these cases? So I share my own, situation with the GAL, because obviously there wasn't enough bandwidth for this person to even understand how I broke down. I made timelines. I had everything, you name it. They didn't take the time to do any of that homework. So, I think that there's a danger here that we need to be very careful of and mindful of, that we're already in a situation where neurodiversity is on the rise. There is a risk of overreach with people that are not trained. So we run into this today already in schools with a school psychologist maybe who has minimal training, trying to come up with a diagnosis. They shouldn't be diagnosing, right? They're not medical professionals. And because of this bill, and actually the burden of proof, we got a little bit of consideration along the lines of the fact that these are not medical professionals. They should not be diagnosing kids. So I would say the same applies to an Office of the Advocate. How can they possibly understand something that it takes medical doctors years and years and years to understand and go to school for? And, so there is a danger of overreach. There's a danger of the risk of understanding the complexities. We already have protections for districts. I heard, special educators, but I didn't hear families. So you're talking about now commingling child's education records. You're allowing them access to things, and this growing bureaucracy will very easily have a way. I mentioned retaliation in the beginning. You bet. Retaliation can happen. It just now opens the door and makes it 10 times more easy for that to happen. And these aren't kids that need, we're not talking about kids in the Sununu Center, kids with behavioral issues. If they have them, it's because they have underlying medical needs that weren't addressed. So, budget aside, whoever does this aside, we need to do the right thing here for families. Listen to the families that brought this up to begin with. And we don't need more Health and Human Services folks and lawyers, bottom line. So with that, I appreciate your time today. Do you have any questions?
Thank you very much. Are there any questions? Representative Lekis.
So ideally, what would you like to see created for the children?
I could tell you it would be, and I did see this solution come about as the bill evolved. And, as I mentioned there, my hackles went up a little bit when I heard about another office, right? I do think there can be merits to something like that. I think it's the way it's approached. I work in software engineering. I hire people all the time that are they're for very specific needs and levels of experience. So I would say it's dependent on, the success of that role, and that position is dependent upon who you get for that, right? It all comes down to people. And I think you need to listen to families and look at what are the set of things that, as we become experts as parents, even in our own kids' needs, heck, we're actually experts in a lot of this too, and I'm not suggesting you hire a parent per se, but I would say we need to keep that balanced with not just reaching into the pool of the same old that we go to, but look at it a little bit differently and maybe a little more radically even, be a little more progressive in our thinking about who we'd want to hire for that. Shouldn't be the same old cookie cutter approach. I hope that answers your question.
Thank you.
You're welcome.
Thank you. Representative Tanner?
Thank you, and thank you for coming today. And just as kind of a follow-up to Representative Lakis's idea, you had mentioned something about that they need to be able to go to an IEP meeting, and it seems like a lot of the frustration is that parents don't feel as though they have an equal footing with the school district and the lawyers and just them. And I think we've had other bills that have come through that have tried to balance that out a little bit. And so unless you had a office of like 500 people that could go out, or deputize them to go out, it just, in my mind, I'm trying to, from hearing you and, my heart goes out to you, but how do you see this being implemented to help the family, because you're advocating at that level?
Right. Well, and I'm happy to follow up with testimony, and I'm going to send everybody the copies of the petition and whatnot, but I also put together a flow chart at one point in time that describes the process. So I think there's some points of failure in the process. And one that really bothers me in particular is, and this will tie back to the number of meetings. So it isn't humanly possible for someone to go to all these meetings, right? No, it's just not going to happen. But I do think that someone should be seeing these meetings, because for someone like myself that's in software engineering and process reengineering, it's very easy to see along the spectrum of the key decisions that are made and the points that decisions need to be made where this gets dragged out indefinitely. And that's done a lot of times on purpose, frankly, and you have 10 meetings instead of one meeting. So I think that a successful advocate could be involved right up front in the process. We also need to look at, there's a part of FAPE, or rather the IDEA process, that talks about that schools only need to consider documentation on a medical diagnosis. And that to me is a real sticking point, because if I'm coming in with Boston Children's Hospital diagnoses of autism or whatever, and I've gone through thousands of dollars to get this child diagnosed, done my job as a parent, right? Jump through hoops, then that should be more than just considered, right? But the wording of some of these things is such that allows the process just keep going and keep going and keep going. So there's inefficiencies in the process itself. And some of those, unfortunately, are tied to IDEA and federal law and some things that we need to change. But I do think that we should be empowered as a state to make some of those changes ourselves and implement differences in process where we can come to agreement earlier on, right? And get those 30 minutes of speech to that child sooner. Like, if you look at the inefficiencies of the whole thing, it's just, we're spending exponential amounts of money just arguing with each other, right? And if we just did the right thing up front, that would save all the rest of that. So to answer your question, no, you can't be in every IEP meeting. You can't even be to every child's one IEP meeting. But I think we need to make a better attempt of really seeing what's happening. And actually, I would invite all of this committee, go check out an IEP meeting, sit in one sometime, and you'll easily see where there's inefficiency. So I hope that answers your question.
Yes.
it kind of does and kind of doesn't. So I was a teacher for a long time, so I sat on a lot of IEP meetings as the teacher and saw what you see sometimes. And it seems like what you're asking for is different legislation to set a different, set of protocols and the way things are handled. I'm just wondering how a $500,000 independent office is going to do that. I mean, we've tried to do that with the Department of Education. The Child Advocacy Group is now trying to look into that with what areas they kind of specialize in. But it doesn't seem to me that this particular bill hits what you want it to. And I'm just wondering if you see that as well.
It's a start in the right direction. Families have no power right now, pretty much. And teachers, I would say, are in the same boat. Okay, so I recently ran for school board in my town, and that was one of the messages that came really loud and clear through to the teachers, and I had them, many of them vote for me. And it was because they can't say anything. They're bound by, and you would know this sitting in those meetings, they have to toe the line to what administration wants them to do. They can't just speak out and say, you know what, I think we should just do this. I think this is a start. It is not going to resolve all of the issues that we have right now. But if we do nothing, we fall back on really lives being ruined. And I can tell you, I testified in another committee and quoted the old, I'm not Catholic, but the Catholic Church has a saying about if you lay the foundation for a child by the time they're 8, then that child's going to have a good footing in life for their morals and their ethics, all that kind of stuff. The same is to be said here. We don't start to solve these problems, you're going to have entire generations of dependent people on the state of New Hampshire. I can promise that. So it's not going to solve everything overnight, but it needs to be the right independent office. It needs to be the right person or set of people. And I think, as I tell my kids, use your mind, use your imagination. The sky's the limit. Why can't we do that here? It's a start. It's better than nothing.
Thank you. Further questions, Representative Lakis?
Could you send to us a list of the failure points that you see commonly happening?
Sure, I'd be happy to do that.
And your flow chart?
Yeah, absolutely.
Thank you.
Yeah, it just, as somebody in the professional world of, 20 plus years, it kind of boggled my mind. And one of my mom advocates is sitting behind me, Moira, here. So I got here because other parents throw each other lifelines. So the process flow, finally at some point I said, Moira, I'm going to sit down, I'm going to put this process flow together and pinpoint where we've got problems, because it blew my mind as a professional sitting through these meetings. And one day actually somebody said, well, we're going to have another meeting. I said, aren't we in a meeting? Or, if any of you have professional work lives, you would appreciate this, right? It's like the Visa commercial, the cost of whatever, and then they get to the end of it, it says priceless. The cost of just getting this done is priceless. And it's not just priceless because of a price tag. It's because there's a little face that you're going to be helping or not helping. So I'll send you the flow chart. I'm happy to share it with anybody. I wish I could get more points across here, but we can do this, and that was my message with the school board and with the teachers. This is pro teacher. Okay. We want kids in schools, right? 3 of mine are out because they couldn't get their needs met. And out, not meaning not in school, but in different options. We want them in schools, don't we? So with that, I thank you all. If you have any questions.
Thank you very
anything?
much. Seeing no more hands, thank you very much.
Thank you.
Christine Metz, M-E-T-Z R-E? Metzner, okay.
Good morning, Mr. Chairland and committee representatives. My name is Christine Metzner, and I live in Rye, New Hampshire. I'm here to support SB 381, and my experience with my son's 504 plans and in the IEP process demonstrates the need, I believe, for a special education advocate here in New Hampshire. I have this 3-inch binder. It's overflowing with emails, letters, plans, notices, meeting notes,
are corrections to meeting notes, doctor's letters, updated doctor's letters, and it just covers 14 months. So I think as I go through this, it might highlight some of the failure points in these processes. When my son was 10, he developed a neuroimmune condition, and among his many symptoms were extreme anxiety, agoraphobia, sensory issues, and cognitive regressions. It was as if he had a traumatic brain injury, but his symptoms progressively got worse. When he was in 6th grade, we developed a 504 plan and later wound up in the IEP process. Now, I'm a lawyer by training. I'm not presently practicing, and I familiarized myself with these laws, and especially for the IEP process, it took hours to begin to understand the framework of the system. I was overwhelmed, and I turned to an advocate and later a lawyer for help. I made it clear to the school what I believed would help my son. Some home tutoring, because his agoraphobia was so bad, he could not leave the house. We had meetings, multiple meetings that my son's psychologist attended, but they couldn't say yes or no to my request. I finally resorted to hiring a lawyer, which made the school start having a lawyer attend the meetings. But once I hired a lawyer, my simple request for a home tutor a couple hours a week was magically granted. This was 4 weeks and 3 meetings after I first made the request. The tutors came to our house for about 2 months until the end of the school year. My son probably had about 20 hours of tutoring, and that was all of his public education for the last 6 months of his 6th grade year. I'm sure you can tell the lawyers made more money than the tutors, not to mention the hours of administrator and teacher times. Come September, the school would not allow further tutoring despite my request, recommendations from my son's providers, his doctors, his psychologist. He was starting to do better, could leave the house, was also very fatigued, so he was on a very part-time schedule. They just would not agree to tutoring until we finished the IEP evaluation process. So when we signed the consent to the evaluations, 60 days passed, no word from the evaluators. So we agreed. The school asked for an extension. 30 days later, still no completed evaluations. I never heard from one of the school's evaluators, and the school's chosen psychiatrist never contacted my son's providers for the information he needed. At this point, there'd been a total of 9 504 and IEP meetings. My son's psychologist was at 6 of these meetings, and my lawyer and the school's lawyers were at 5 of them. Meanwhile, my school was getting 2 hours of education a week at school. We finally decided to homeschool our son. He was not getting free and appropriate education, and although the school didn't necessarily abandon him, the school was kicking the can down the road. While I was homeschooling my son, I was shocked by how many people are homeschooling their children because of the difficulties they face in 504s or IEPs. There's not even statistics on that. Nobody keeps that in the state. Parents of children who need accommodations or services need an office to turn to for help. I mentioned earlier that I'm a lawyer by training. The procedural safeguards aren't written in plain English, and I had trouble understanding them. I hired an advocate, then a lawyer, and if I needed him, imagine a single mother with a full-time job and children with significant educational needs, or someone for whom English is not a first language. You know, schools are spending more and more on legal fees. My own SAU has talked about increasing legal expenses in their budget because they see a trend of advocate outreach by parents. I'm not sure what else parents are supposed to do. The schools get so much training from law firms, and there's no reason for them to hire a lawyer for individual 504s and IEPs. I've seen no indication that schools are asking why parents are seeking more help. Parents don't fully understand the process, they don't feel heard, and are quite likely overwhelmed. I'd like to address the position of the Office of the Child Advocate. One thing I think about here often is that the Office of the Child Advocate, as I understand it, was created to provide assistance for children in cases of abuse or neglect or in the juvenile justice system primarily. That doesn't, there might be some overlap with special education, but I would be shocked if, I don't believe there's a majority of children who need special education and the Office of the Special Education Advocate who also have children in the DCYF system. And in fact, I actually sort of see that as a conflict of interest. I don't know how the Office of the Child Advocate would address those situations. And especially the Office of the Child Advocate is for people, parents, families who are trying to do the right thing for their children. I'm happy to say that my son is now quite a bit better. He's improved substantially. He's returned to public school and he's now thriving as a sophomore. If anybody has any questions, I do have my written testimony.
Thank you very much. Are there any questions? Not seeing any. Thank you very much.
Thank you.
I'd like to invite Jane Bouchard.
Morning. For the record, my name is Jane Bouchard, and I am the Executive Director for the New Hampshire Association of Special Education Administrators, and I will keep my comments brief. My written testimony is going around. You'll see from our testimony that we do recognize the importance of this kind of an office, but would respectively raise several questions and concerns. The first point that we want to bring forward is that the New Hampshire Department of Ed currently has a process for investigating special education complaints. And currently there really is no real evidence that this process is not being provided and that the department is failing to do their job in terms of investigations. And I'm sure the department can give you specifics on the numbers of complaints that come forward and how they are reviewed and dealt with. The second point that we want to bring forward is that IDEA makes each state agency responsible for the oversight of services to kids with disabilities. And we don't see that there's a need to have a duplicate office for that, and feel that New Hampshire is sufficiently meeting those needs in terms of the oversight of services provided to students with disabilities. We also want to point out that currently the Bureau of Special Education is understaffed. There's only one position within the Bureau that's state funded. The rest of the positions are federally funded, and would raise the question as to whether or not those resources that are in this bill, whether or not they should be dedicated and directed towards the Bureau of Special Education to enhance their current processes and procedures. We also brought forward several other questions within the testimony in regards to some of the specific language, and some of that has already been mentioned. And in closing, we would say that, you know, in general, we feel as though this bill just recreates a duplicate system for one that already exists in New Hampshire. So I would open it up for any questions that you might have.
Thank you very much. Are there any questions? Not Representative Lekis?
I'm hearing conflicting things here. You said everything is being handled, that people are all doing what they're supposed to, and yet we have lots of parents coming and saying it's not being handled. And so do you have a sense as to why this dichotomy?
Thank you for the question, and I think that's a good one. And I would suggest that we really dig deeper at the data and the number of disgruntled parents versus those who are satisfied, and really looking at what some of the critical issues are. I would say that the vast majority of parents in the state are satisfied. And if there are, you know, areas in which we need to improve, we're certainly open to doing that, and would
really suggest that we dig a little bit deeper at the data. We heard this morning about the large binder of complaints and would really say, you know, how many parents are those? And no parent should ever be disgruntled, and no child should ever not get their services. And we're willing to deal with that. But to bring forward legislation on small numbers, we may want to look more closely at that.
Thank you.
You're welcome.
Are there further questions? Not seeing, yeah, Representative Luno.
So thanks very much, Mr. Chair. Thanks very much, Jane, for taking my question. Just a real quick one, just so we can put this in context. Approximately how many special children are receiving special education services in New Hampshire?
I think Becky could really give us the specifics, but I think it's around 17% of our student population.
Yeah, so that would be around the 30 to 35,000.
I believe that's right around that number.
So, thank you.
Those are the numbers which we have. It's usually hovering right around 30+ thousand students dollars. Okay, further questions? Did you have your hand up?
Thank you. Thank you very much. And thank you. I was just thinking the same thing actually when we're hearing that there's a petition of at least 700 people. That sounds significant. But I suppose putting in perspective with 30 to 35,000, I can see both sides. I'm just curious if anyone has taken or had the chance to dig into the data to see if maybe there are certain districts that we're running into issues with more so than others, and maybe that needs to be addressed versus legislation.
And again, I think that would be something the Department of Education could answer. They're the ones that deal with complaints and could probably give you more information on that.
Thank you. Further questions? Not seeing, thank you very much.
Thank you.
Mariah Ryan.
Good morning, Mr. Chairman, and committee members. My name is Maura Ryan, and I'm a parent advocate and a parent of a child currently in school who has special needs, who has autism. I want to sort of answer some of the questions. 700 people on a petition is significant because of the incredible retaliation that parents get when they don't agree with the school district. I also wanted to address that OCR can only take a complaint for 180 days, which passes in the blink of an eye. And a due process hearing only goes back 2 years, which is even less than what we allow for our court procedures, which is a minimum of 3 years. I also wanted to add that we had a parent survey done by the Department of Education, which indicated a lack of satisfaction with special education services. And it's well known nationally that special education services are not on par with where they should be. In our particular state, over 97% of the students who are in the IEP pool have normal range IQs. Less than 3% have developmental and intellectual disabilities. So they should be capable of maintaining proper academic records and be employable. However, that's not the case, and that gets shown in the proficiency scores, which are in single digits right now. For right now, students with IEPs are less than 10% for both reading and math. As for the Parent Information Center, the Parent Information Center can provide free consultations to parents to talk about some of the issues that they're facing, but they don't attend IEP meetings and they don't get involved in due process. They do have an advocate on staff who will charge a parent $30 an hour to go in, and they will do a file record review. A file record review is where they read the review and they make recommendations, and what happens is the parent goes into the meeting, lists the recommendations, and the school says, oh, well, we don't really have to do that, which is very frustrating to the parent because they've just spent $30 times 20 hours for a file review, which seems like it's a significant chunk of money for a parent, particularly who doesn't have those resources. It's been nationally recognized that special education has been a challenge for our country. There are other countries that are doing far better. My son is now 18. My cousin has a kid who's 5 years younger than my son, who already speaks 5 languages and is more proficient in academics because she lives in our home country. And their education system is better geared towards dealing with children with disabilities. We need this person. I support SB 381. We need this person to be an independent special education literate person. Special education is a very, very specialized field. I know a lot of about special education because I've been breathing it 24/7, 365 for 18 years. That's a long time. I mean, I had to get up at 5 o'clock in the morning. I drive my son between 3 different schools. He has 12 different doctors, all of whom I manage. So it's overwhelming enough for me to deal with the basic aspects of his care, in addition to which I have to become a special education expert. It's important to note also that special education complaints on the federal IDEA Part B increased 500% last year. 500%. Many parents came and spoke out about the problems that they were having in the 581 committee, and it's very difficult for them to come and try and come up here, find parking, come up in, many parents work because they have to pay for therapies. I know that in particular, I've paid for Orton Gillingham for my son for at least 7 years to a total probably about $70,000, which is something he should be getting at school. That is what he's entitled to. My son attends school in Manchester, and there's a colleague of mine, Luis Maldonado, who posted on Facebook, why is it that I have to have a lawyer involved in every aspect of my child's special education process? When does it end? And the truth is, it never ends. It never ends. Shannon Bouchard was someone who I was trying to help, and she wrote to several of you because she contacted the Office of the Child Advocate, and she got a blow-off email in response and was told to write to a general email, and she never got help. Her kid's been out of school for almost the entire school year. There are people who have written entire theses on how school districts can cheat certain parents, single mothers, people of color, low-income families, military families, cheat them out of their kids' special education needs. And the end result is that almost 20% population of kids who are on IEPs are coming out not capable of holding employment and not fully educated because schools follow the de minimis standard, which is basically the very, very basic bare minimum. So you have 20 members of this committee. That would mean that almost 4 of you would be incapable of functioning on this committee, incapable of living by yourself, and incapable of being fully functionally literate. There are certain disabilities that have not been dealt with effectively because they're newer. Autism in particular is one of them. Rebecca Fredette said the increase in cases of autism in our state have increased 666%. And yet school districts still do not know how to deal with autism. Medical science is advancing faster than educational policy is, and they're becoming better at adapting kids to their environments than school systems are. And the problem is that medical science is getting completely disregarded by the educational school system. I think the $500,000 to establish this independent office is a drop in the bucket compared to the millions that will be spent supporting the almost 20% of the population that will not pay taxes and will not be able to be functional. My son right now got a 28 on his ACT, has a genius level IQ, and he is not able to function academically in school, has no future in college, and cannot hold a job. And he should be able to. So my ask is that you support this bill because we, the parents, want an independent educational advocate. We feel that this is necessary because the system is not working. And the proof is in the proficiency scores, and the proof is in what parents write to you, and the proof is in all these pages where parents are saying, where is the help? Our kids are not getting their education.
Thank you very much. Are there any questions from the committee? Thank you. We have one card left. That's Rebecca Fredette from the department. Is there a need for any technical input from the committee? Okay, Rebecca.
Thank you.
You're welcome.
Good morning again.
Good morning.
May I, Representative Lai?
Go ahead.
Thank you. During the testimony, we heard from different people about the special ed at DOE and the process. Some were saying there is a process, there is a step process for you folks down there to take parents' concerns, issues, non-compliance in their opinion, and follow it all the way up and adjudicate that some way. And then we're hearing it's not. So can you just tell us in a very brief format?
Yeah, we're required by IDEA to have a dispute resolution process, and we do have one. It includes complaints and it includes due process hearings as well as mediation. We also provide IEP facilitation to districts. And I do have numbers on complaints and due process if you wanted those. I know that was a question. Yep.
So the follow-up to that is then, so if I am a parent that we heard this morning, if they go through your process at DOE,
Yep.
Somewhere something is resolved, typically?
Yes. Yes, if they go through one of those processes, there is always either it's dismissed or a resolution to a complaint or a due process hearing. Yes.
Okay. Thank you, Representative Lai.
You're welcome. Representative Luna?
Thank you very much, Mr. Chair, and thank you very much, Ms. Fredette, for joining us. So, when the department looks at complaints, do you look to spot trends that might exist?
Yes, we do. So I work closely with Natasha Lupiani, who is the complaints person, and we will discuss whether there are trends of certain districts or if there are certain types of complaints that we're getting, so that we can address those complaints either globally to all of the special education directors or targeted to a specific district. We do have a very small number of complaints each year, so it's hard to find a trend with only 34 complaints each year.
Yes, you may.
And so based on spotting trends and based on the corrective action recommendations that you make, has that in I guess the cases where you've been concerned addressed those trends and brought the numbers, say, more to what you would expect?
So our numbers for complaints and due process are pretty consistent from year to year. Even over last year with the pandemic, we still are right around the same number of complaints each year. So we haven't seen a drop or an increase in those complaints.
Representative Porter?
Thank you. So what's your consistent number of complaints usually?
So this year we have 34 complaints. I'm just going to pull it up because I have it on my screen. I apologize. So this year we had 34 complaints for fiscal year 21. 9 of them were withdrawn or dismissed. 25 of them did have a decision. And of those 25, 15 of them were found findings of noncompliance. So that would be where the district was found to be noncompliant.
Thank you.
Yep.
Representative Tanner, did you have your hand up?
Basically, I wanted the statistics like Representative Porter. What happens when the school is found in non-compliant? Is that corrected?
Yep. So they're given, when they are found non-compliant, they're given a letter of correction that is developed with Natasha, Diana Fenton, and the commissioner, and a decision is made as to how they will correct that, and if there is anything else that needs to be done regarding that complaint.
And just as a follow-up, is there any kind of satisfaction survey or survey like exit survey from the parents to say how they felt the whole thing was handled?
No, there isn't currently.
Thank you.
Yep.
As a follow-up to that, we had a survey provided the group that was looking at this from the department. Could you provide a copy of that survey to all members of this committee?
Are you referencing the 603 Bright
parent
Futures
survey,
that has
yes.
the indicator 8 portions of it?
Well, that must be it. I have it. I have a copy, but I don't
Yeah,
think.
indicator 8 is our family engagement portion, and we include it in the 603 Bright Future survey.
Yes,
but
yes, that's it.
Yep, I can send those numbers to you. Yes.
Okay. And the last question I have for you, and maybe it's best directed towards the senator, but we have a performance audit going on at this point in time. Do you have any idea where we are on that? Are we nearing some point? Oh, okay. Wow, we're at the top side of it. Further questions of the department? Yes, Representative Lekis.
Does the department do something to make sure that all special needs students know of what you can do, what you provide, etc.? Because it seems there's much bigger than 34, or it was, you know, a large number of parents who were unhappy, but you're only seeing a small number of cases. And I'm wondering where that breakdown is and why you have parents who aren't being helped, but you're not seeing them.
So currently, we require that the districts provide procedural safeguards to each parent, which offers them all of those, kind of outlines all of those for them. But after the hearings this summer and then the Senate hearing earlier, we have been in the process of developing parent trainings that we're going to be providing about how to do different processes within the department. So that is something that's on our radar and we're in the process of developing.
Thank you.
You're welcome.
Thank Representative Mullen.
Thank you, Mr. Chair. I almost missed my opportunity. Thank you, Ms. Fredette, for taking my question. In fielding the complaints, do you have a sense of whether or not complaints generally center around parents wanting more than school districts are offering? And if so, how would a school district determine where that line was?
So our complaints are kind of widely varying. There's no, like I had said, there's such a small portion that to find trends. We did find trends during the pandemic of lots of complaints or calls around masking and things like that. And then you may find complaints about whether services were provided during the pandemic. But typically it's kind of it depends on where the student is, who the parent is. It's not a consistent, there's no, with such a small number, there's no consistent pattern that we see that we could pull from to try to get some of that addressed, unfortunately.
Thank you, Mr. Chair. Just the second part of my question then, without the first part. How do districts determine that one child is going to get 10 hours of reading or math assistance and another one is only going to get 4?
Sure. So each student has to have a annual not annual, a 3-year evaluation. And so within that evaluation, they should be reviewing what the students' areas of need are and what their strengths are. And then from there, they would determine the services. Once you've determined those services from that evaluation, each year they're supposed to provide quarterly or trimester progress reports to tell how the student is doing and progressing on those skills that you've targeted that were identified in the evaluation. So through those 3 years, you target those skills, you work on those skills and provide progress reports. So it's pretty scripted about how you become eligible, what the eligibility requirements are, and then once you've done all of those evaluations, you should be using your evaluations to determine services and what the child needs to address their needs.
Thank you very much. Are there any further questions, Representative Lekis?
This is sort of a technical question as you were explaining this. Both I experienced with my granddaughter, but I also have heard lots of other parents say the same thing, is that a child has specific needs, they get an IEP, they're being provided those needs, they do better. And because they're now doing above a certain performance in school, it's determined that they don't need an IEP and don't need those needs, but it was those special things they were getting that allowed them to do better. How does that all work?
So the team should be discussing that and should be saying, will the student continue to be successful if we take away those supports, or does the child need to have those supports to be successful? We would hope that those teams would be having that discussion and would be looking at that. There are some students who, if you took them away, they've made enough gains and they've kind of closed those gaps that you could take the services away. There are other students that you really need to look at that and say they still would not be successful if we took those services away. So that should be a discussion that each IEP team is having when they meet on the student.
Would that be something that a parent could come to you if the school decided one thing and they were seeing something different?
Yep. So Natasha, as I said, Lupiani takes all the complaints, but she also answers, just because I don't have time, she also answers a lot of parent questions. So she will walk parents through the process. She will talk to you about the different options you have. She'll provide you to some resources that might be available. She's only one person, but she does, she does answer that. If it's something that she's unclear of, sometimes she'll pass it on to another member of my team. So we may pass it on to somebody who has more experience in an area than she does, or she consults with us repeatedly to try to get that answer correct to make sure that we're providing information to the parent.
Thank you.
Thank you very much. With that, we're going to, Representative Ford.
Has anyone ever been prosecuted for denial of services to a child?
There have been due process hearings where children were not receiving services, and the district was ordered to provide the services or provide compensatory services, yes.
Thank you.
Not seeing any further questions. Thank you very much. And this will close the hearing on 381. We are going to take a 5-minute break for everybody to stand up, stretch, and we'll come back and start this up right again in about 5 minutes with the next bill, which is 394.
That question. I told you we're looking for a tenacious lawyer who wants that this time to go.
That, it just, I've heard testimony. And they don't.
Thank you, sir. Reference. Yeah, right. Okay, we're about ready to get going here. Everybody try to find your seats.
I have an amendment for 394. I have a card in here. Yep.
This it? Okay. Okay, we're ready to open up this hearing on Senate Bill 394. And I'd like to welcome Senator Jay Kahn to our meeting, present the bill.
Thank you, Mr. Chairman, and members of the House Education Committee. I'm Jay Kahn from Keene, State Senator for 15 of 23 towns in Cheshire County. I'm here today to present Senate Bill 394, which deals with our definition of a child with disabilities under special education law. The bill that is 394 is very similar to a House bill that you considered earlier in the year, House Bill 1513, which we have in the Senate Education Committee and are considering. We had a hearing on that bill this last week, so it's kind of fresh in my mind. The wording between the two bills is almost identical. So where House Education ended up and where Senate Education ended up is very much in the same place. So let me explain that place. We currently have special education services provided to students between the ages of 3 and 21. So that services cut off at 21 years of age. When this has been debated in the legislature over the past few years, and Mr. Chairman, you probably recall this a couple of years ago, but the testimony around it was parents wanting their student to be able to complete a school year once they reached 21, so that when there wasn't a cliff, that in fact an IEP, individualized education plan for a student when they reached 21 wouldn't just end on their 21st birthday, but in fact that student could continue to the end of that school year. And that's what you did in House Bill 1513. And that's what we did in the Senate in House Bill 394, which is before you today, is explain that change. That has a fairly minimal fiscal impact on our schools, public schools in the state. And the reason why is because most of the school districts in the state are already doing that. It makes good sense to do that. When a student is going through that kind of service, the goal of the IDEA 221, whenever the handoff is to developmental services, state developmental services, the goal is that a student, to ensure equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. So that's why it's important to complete the plan and to provide as much of a transition to those goals, which are the IDEA goals. All right. So that's the good part. I think that's the easy part for us. The more difficult part that you're going to hear, that I've been hearing through our Senate hearings, is that Other states have gone to court in the last year. Let me lay out the landscape in the nation. There are 8 other states that were at the beginning of this year at the same place that New Hampshire is. 221. There are 13 other states that have language that we are intending to go to, which is 221 through the school year in which they turn. But there is a recent decision in Rhode Island versus KL, and it was decided in the federal district court that they needed to provide services through 21. Through 21. That's a cost that we don't know. I don't. Maybe somebody can put numbers on it. But it's not only what the cost is in total, it's how would it be parsed out, right? So here are some of the guiding statutes that we need to try to bring into this. One is 189.1, which is what we are amending here, which says that I'm sorry, 186C2 is what we're amending. That's the definition of a child with disabilities. In 189.1A, we described that our duty to provide public education is until a student has acquired a high school diploma or has reached age 21. Age 21. I don't know what the other states that have gone through this litigation process had as their language, but our requirement is consistent, right? School age is to age 21. Special education age is to 21. So at the current time, we're consistent. But the courts have said that if you provide other educational services like adult education, you need to go through 21, which is the federal definition if you don't have state language. If I've complicated this enough, good, because it got more complicated through this session, I think, as we learn more about the court decisions. And so the question is, what do we do next with this? I think the fact that 2 education committees studying this question arrived at the same place is a good starting point. We need to get through the school year when a student turns 21. But we can't miss the question that the Department of Education is raising about how do we prepare ourselves for the fact that we're likely going to wind up at through 21 at some point down the road. So what I'd like to do, Mr. Chairman, is work with you and maybe somebody else who was involved in your decision here to propose alongside through the school year as we have it in this bill, an amendment that would bring it to a study commission, that we create a study commission alongside this bill that would involve stakeholders and determine how we need to modify 186C18, which is how we reimburse special education services. Because these are not going to be simple special education services for students who have not completed a high school diploma at age 21. These will be more complex. These will reach the thresholds that we've got in special education funding. So school districts are not going to cover the costs with $2,000 of additional adequate education aid. They're likely going to be covering the costs up to 3.5 times their average cost of instruction, like $70,000. covering all those costs. And they'll be covering 20% of everything above that till 10 times, which gets us into the 100 plus $1,000 potentially per student, and we need to walk through this, I think, in some studied manner in the coming year with the Department of Education providing advice and school districts telling us how are they going to be able to accommodate this and be able to prepare for this in their school budgets. This bill already has an implementation date of 23-24 school year. So with the study commission running through that 23-24 school year, we ought to be able to have some better information for the legislature to be prepared to act in a second step down the road. So that's hopefully I've laid that out, and I'm glad to answer any questions, Mr. Chairman.
Well, Senator, thank you very much. And it just, already the figures are going through my head here. Are we talking roughly around $5 million per year?
It could be that, and it could be north of that.
Yeah.
Yes, and how that gets parsed out between the school aid formulas and
Huge
the categorical aid that we've got for special education needs to be considered.
Thank you. Are there questions from the committee? Representative Luno?
Sure. Thanks very much, Mr. Chair, and thank you very much, Senator Khan, for bringing this in, and also for adding that level of complexity to what we thought was a more straightforward issue. But I really appreciate you actually bringing up the language from 189 1A, and I went and took a look at it, and if that were to be amended to has reached the age 22, would that basically also be saying that that any student would have a right to attend their public school until they reach the age of 22?
It would.
Any student.
Any student.
Thank you.
It's part of the quandrum.
And just to reflect on what might be the complication there, 22-year-old students in school with students who are 17 can pose some, challenges to manage the different age groups and their, what they are entitled to do, which is, it might be substances.
Yes, go ahead.
Yeah, and thank you very much, Senator. And when we're talking about all students, I'm not just talking about special education students. I'm talking about students that might choose most students choose to complete their high school, requirements and graduate with their class when they're 17 or 18 years old. But should a student want to take maybe more electives or other classes that don't necessarily tack on credits that lead to graduation, they could extend that out through age 21 under current law and 22. Is that correct?
Well, 21 under current law.
Right.
And or until they graduated. So many students are completing all the credits that they need for graduation by the time that they reach 17 or 18. I mean, the goal is for students to complete a high school education, not to continue to, I don't want to go too far down that path, but that's what I take as our primary goal, is to help students complete a high school competencies and qualify for graduation from a public high school. Not necessarily to provide adult continuing education, which school districts can continue to provide.
Right, and the Charter Career Academy is sort of leveraging that by delaying the high school diploma until a student has taken 2 years of community college.
I understand the proposal that there is for that kind of program.
Right, thank you.
We don't want to go down that road.
It's all tied in.
Yeah, I understand. Representative Lekis?
Thank you. I have two questions, one totally unrelated to each other. One of them is, what does a person do now once they reach 21 and they can't support themselves and all of that? Who pays for their continuing care, et cetera, as it is now?
Thanks for that question. So once a student ages out of the services provided through public education, adult developmental services, the regional offices will provide adult services through Health and Human Services, the regional offices for developmental disabilities, and that's the transition.
Thank you. And then, can I-
Follow-up.
yeah, the other one is, would a student be required to stay in until the end of the year? Let's say they turn 21 and they were looking forward to being done with school, even though they could use more schooling. Who makes that decision at that point?
Thanks, good clarification. A student doesn't need to graduate from high school. And that happens. We know that happens, whether you've got developmental disabilities or not. And so there's no requirement to stay in school. And in fact, some students and their families will decide that it's not in the best interest of the child to continue to receive educational services, that in fact a different kind of transition should happen. And developmental services will provide some assistance below 21 years. And that is that transition handoff is always of concern to the families.
Whoops, thank you.
Are there further questions, Representative Woodcock?
Thank you, Chairman Ladd. Senator Cohen, good morning. I just want to be clear on your amendment dialogue. Are you asking us not to move forward with 394 as it's presented, or are you asking us to move forward with 394 and in addition attach an amendment to it?
The latter.
Okay, thank you. Thank you, Chairman Ladd.
You're welcome. Further questions? Thank you very much, Senator.
Thank you.
I'm going to take the liberty here, rather than going with the next elected official here, Representative Cordelli. I'm going to ask Chris Bond from the Attorney General's office. Come on up. Welcome.
Thank you, Representative Ladd. Thank you. So for the record, my name is Chris Bond. I'm actually counsel to the Department of Education and the State Board of Education, but I also serve in a dual capacity where I am affiliated with the Attorney General's office, and I'm actually here on behalf of Attorney General Formella today to testify as to the potential legal challenges that not having the special ed services run through age 22 or through age 21 inclusive, i.e. up until the 22nd birthday, may pose. So I think Senator Khan did a nice job sort of explaining. Just to elaborate a little further, the case at issue, just for the record, is KL versus Rhode Island Board of Education, and the citation is 907 F3rd 639. So I just want to clarify, it is a First Circuit Court of Appeals case. So in the district court in Rhode Island actually found in favor of Rhode Island and found that it was okay to not provide the services up to age 22. But the First Circuit reversed that on a 2-1 decision. That's the decision here. That is, as it's the First Circuit Court of Appeals, that is binding precedent on New Hampshire. So New Hampshire is bound to follow this case law. And that's the reason why we believe it would be a significant challenge for us to defend a law that, and there would be a significant risk that the law would be held to be incompatible with the IDEA if it were challenged. And just to go through sort of the logic of the case, The IDEA provides that states are required to provide a free and appropriate public education to all children with disabilities residing in the state between the ages of 3 and 21 inclusive. And that 3 and 21 inclusive language has been held to mean until the child turns 22. Now there's an exception to that at 20 USC 1412 A1B1, which says that the obligation to provide a free and appropriate public education to those children does not apply with respect to children aged 18 through 21 in a state to the extent that its application to those children would be inconsistent with state law or practice. And so New Hampshire and many other states had relied on that exception to not provide the services up until the 22nd birthday. But what the court found in this case was that because Rhode Island had public dollars that supported adult education programs beyond age 21, that they could not avail themselves of that exception. So specifically, the factors that the court says the First Circuit will look at is whether there's a significant level of state or local government funding for adult education, whether there's public administration or oversight of that educational process, and whether that process is designed to bring students up to the level they would be at if they had completed high school. And they found those present here and then found that that exception didn't apply. So there's a significant risk that if they looked at New Hampshire's program, they might make the similar conclusion, which is why we felt it important that committee understand that that's the substantial risk if they don't move that age up to 22. And I'm happy to take any questions.
Okay, are there any questions from the committee? Representative Waltz. Attorney Waltz.
Thank you. So are you familiar with House Bill 1513?
Yes.
Okay. So what I'm hearing you say is that House Bill 1513 is consistent with federal language, but that Senate Bill 394, if we were to change it from 21 to 22, is consistent with the requirements of the First Circuit. So that, because I'm looking at 1513, that's exactly what I'm hearing the languages in federal law.
Mhm.
But that we would have to provide services through 22. So I think
Up to the 22nd birthday. I may have misspoke. Through 21 inclusive is the requirement. Up until the
I see
22nd
what,
birthday.
okay.
I
All right.
apologize if I wasn't clear.
Well, it was probably me not picking up the nuance. Okay, but again, 15, the House bill is the one that's consistent with federal law. So
Yes.
if we adopt that, then we're going to be consistent with the First Circuit decision. Then it just becomes what our practices are.
I'm sorry.
It's not consistent with the First Circuit. All right, my confusion. Okay.
I am familiar with the bill. I had seen versions where it went up to the 22nd birthday and amendments where it didn't, and I don't know where that bill currently sits. But if it does it, to be consistent with the holding in KL, it would have to go through the 22nd birthday. But I also want to make clear that I'm just highlighting the significant risk the state faces, that there could be an argument that the adult education program in New Hampshire is significantly different from Rhode Island's in such a way that is meaningful. We haven't done the research to know that. That would be probably a pretty discovery intensive process to figure out what it was. But the state, it is clear from this decision that Rhode Island wasn't funding all of adult education, and they had some administrative oversight, and those were found to be sufficient. So I think that just heightens the risk. But I just want to be careful that I'm not.
So it sounds to me like the bill that would have the least exposure for the state is to simply say we're going to provide special ed services through a 22nd birthday.
Yes, that's my understanding. And I should also add, I meant to add, we are aware of one advocacy group that we believe is preparing a lawsuit against the state, but they're waiting to see the outcome of this legislation. And then I became aware of another parent who is preparing a due process claim against their school. So it's not just the risk that the state will be sued, but there's the risk that individual districts will be sued too on the basis of this. And we are aware of at least one due process claim that was brought against a school district on the basis of the KL case. That case was settled. So I don't know what the results of that were. I wasn't privy to the settlement, but my assumption is that the parent got the services that they were requesting because it was a pretty quick settlement after the filing.
Representative Moffett, do you have a question? Okay.
Thank you, Mr. Chair, and thank you for taking my question. You just mentioned a parent bringing a suit. So given the age of majority being what it is, my question is, what about the, I hate to say child, although the word child has been used over and over with regard to this legislation, and I'm a co-sponsor of 1513, but what if the student is at odds with the parent on, if they're a special education student, do they surrender their sovereignty? What if the student and the parent don't agree on the course of action for a 20-year-old or whatever?
Sure, that's a great question. First of all, I want to correct my statement. I said the parent. I actually don't know if it was a parent. I should have said a student. I don't know if it was a parent who brought it on behalf of the student or the student who brought it in their own capacity. I believe that would be, my understanding is that would be on a case-by-case basis. You could have a child who had some sort of a court finding that past the age of majority, they still had some sort of a guardian who could be the parent. But in other cases, just because someone's on an IEP certainly doesn't mean that they're not competent to make those decisions. So there could be either situation. You could have students that could make those decisions themselves, whether to stay in school, for example. As Senator Khan noted, there's no requirement to graduate from high school. So a student who's eligible for these services doesn't necessarily have to participate. Whether that's their decision or the parents would depend on the individual circumstances and who had been adjudicated to be competent to make decisions for that child. That's my understanding.
Sure. Okay. Thanks.
Thank you. Representative Luno?
Thank you very much, Mr. Chair. And thank you, Attorney Bond, for joining us this morning. So would school districts, if they wanted to, under current law, be able to provide education through 21 inclusive today?
Yes, my understanding is that they can, although under the current statutes, they wouldn't receive any reimbursement from the state for special education services beyond age 21.
Okay, and a follow-up on that?
Yeah.
Would they receive the adequacy grant from the state for those students?
I am not certain. I would have to look at that and get back to you. My assumption would be no, but I don't know for certain.
Yeah, no, thanks. And I think that would be, obviously, I think all this is sort of funneling into what Senator Khan is proposing and really understanding this. But yeah, I was interested in what the definition of ADMA currently used in law. And just so we all happen to have heard a bill last week on ADMA, so I was looking at the definition of that, and it's not clear to me either.
Sure. I haven't looked at it recently, so no.
Thank you.
Representative Porter?
Thank you, Mr. Chair. And you might not know the answer to this question, but the reason why these bills were brought forth was because parents were concerned about losing services mid-year for their child. What do they do in other states? I mean, if we bring it to 22, and you turn 22 in May or June or March, or you're going to end, it'll be the same problem, just moved up a year. So there is no solution, you're saying, you think, to this problem? Other than getting into the rabbit hole that Senator Khan said?
Well, thank you for the question. First of all, I want to make clear I'm not here to weigh in on any policy matters, and so I certainly understand that's an important consideration. I would say there's nothing I see in the KL decision that would prevent legislation that would say you can complete the school year or the semester once you achieve age 22. But if you're going to try to cut it off before 22, that's when you run into the KL decisions. So, the merits of cutting off mid-year or not, I understand that. So, there are, so Rhode Island has made this change because they were the direct subject of the lawsuit. Maine, upon seeing the decision, and they're also in the First Circuit with us, so this is binding precedent on them. They have made the decision to go through through the 22nd birthday, not through age 22, through the 22nd birthday. I don't know whether that continues beyond that to encompass more of a school year. It could, but that would be sort of a policy discretion area. So, yep.
Thank you. Are there further questions from the committee? Yes, Representative Cornell.
Thank you. Thank you. So if their birthday is in November and they turn 22 in November, so we're just kind of perpetuating what we were trying to do away with, and they could say, okay, you're 22, it's November, you're not going to finish the school year?
Yeah, so I think if I'm understanding the question correctly, yes, what the IDEA requires, according to KL, is that in a state where there is public support for education as defined by the KL court, and I don't want to get too specific about that because that would be the subject potentially of a lawsuit, but in that circumstance, the special education services need to be provided up until the 22nd birthday. So you could have a cliff scenario where November 15th is the birthday and that's the last day and they were in class on the 14th and they're not there on the 16th. You could do that. I can understand why, for policy reasons, that might not be palatable. There's nothing that would prevent you from letting them finish out that school year. But if you try to do it on the other end and you try to say, well, once they reach their 21st birthday, we'll let them finish, then you've got a problem, because if they're still 21 when the next school year starts under this potential whole application of this holding, there'd still be a problem. So you do have that flexibility, but only when you're over the sort of limit that's set by KL, not before.
Thank you. Are there further questions from the committee? Not seeing any. Thank you very much. Good
Thank you
luck on this.
thank you very much. Thank you.
Representative Cordelli.
Thank you, Mr. Chairman and fellow committee members. For the record, Glenn Cordelli, representing Tufton Borough, Moulton Borough, and Sandwich in the beautiful Lakes region. You've heard quite a bit of testimony about age 21 inclusive, Rhode Island, Maine, and so forth, and the need for us probably to do something. We did have HB 1513, which passed the House and was sent to the Senate. I attended the hearing on that in the Senate, and I got the impression that the Senate might look to amend that bill based on some of the similar testimony that you just heard. My amendment that is making its way around the committee basically says that it's not just 21 inclusive, but if they turn 22 on Thursday, they can finish out the semester. They're not kicked out of school the day after their 22nd birthday. I don't think that that's reasonable as a policy for the state. I had done some research trying to find out how other states approach it. The only thing that I could find in a chart, a global state-by-state comparison, actually dated back to 2004 with a document from the U.S. Department of Education. So it's a little bit old, a little bit dated, but even back then it was all over the place in terms of what states did in this regard. And there were certainly states that said up until their 22nd birthday. And I've talked to an education advocate here in New Hampshire who thinks they should leave school on, right after their 22nd birthday. But I'm taking the approach in this amendment for your consideration that they would finish out the semester during which they turn 22. I think that's a more reasonable approach for us as a policy, and also for the student and their family. And I thank you very much for your attention.
Thank you. Are there any questions for Representative Cordelli? Representative Bohm, and then Representative, I think Tanner had her hand up.
Do you know, thank you, Mr. Chairman. Thank you, Representative Cordelli. Do you know that if all high schools in the state run on a semester program?
I'm not sure.
So those that don't, it would mean to the end of the year rather than the end of a semester.
Representative Tanner.
Thank you for taking my question. Very similar question. Our school year, the school year that I worked under, was divided into 4 quarters. And I'm just wondering if semester is defined anywhere in statute or whether we need to have a better definition.
We certainly could play with the terminology of semester, certainly.
Are there further questions? Representative Luno.
Sure, thanks very much, Mr. Chair. How would this work for students with EFA accounts?
Let's see.
I'll clarify.
That those programs should follow the law in terms of the definition of a child with a disability.
Follow up?
Yes.
So we've already concluded that under current law and under whatever language comes out of 394, that the age, whether it's until they turn 21 or until 22, they turn 22, that a student would be entitled to essentially attend school and potentially and have that school receive the adequate education grant. And I believe the adequate education grant formula is what the EFA program follows as well.
Correct.
So I guess very straightforward. Would a student who has an EFA and being homeschooled, any student who has an EFA and is being homeschooled and potentially going to private school, be able to receive that EFA grant from the state until the end on your amendment here, until the end of the semester in which they turn 22 years old.
Thank you. Just thinking about it as I think back on the legislation for the education freedom accounts, I think it says 3 to 18, but I would have to go back and look at the version that was actually signed into law.
Are there further questions? Thank you very much. Got 3 more cards here. Jane Bergeron.
Good afternoon. For the record, my name is Jane Bergeron, and I'm the Executive Director of the New Hampshire Association of Special Ed Administrators. And thank you for the opportunity to testify. I will keep my comments brief. Our association certainly recognizes the importance of providing services to students with disabilities through age 21 or different scenarios that we've discussed today. Some of the things that we would like to bring to your attention is based on the fiscal impact and making sure that our policymakers fully understand the implications upon our taxpayers. You will note that the fiscal note with the bill is focused on and dedicated to children and youth who are placed in residential settings and those who are placed in alternative school settings. We know that this bill will impact a good number of kids with disabilities in our public schools, and those numbers are not included or considered in the bill. So when you think about your kids who have transition planning, our younger adults, they tend to be young adults who have quite a bit of services and support. So many of them are out in the community. They require specialized transportation. They require job coaches. Some have one-to-one nurses. Some have behavioral specialists with them. Many of these services are contracted out to vendors to provide these services out in the community. And so as you think about a bill like this, do consider the numbers of kids who are currently in our public schools, not in residential schools or in alternative settings, because that certainly will have an impact on our community, our taxpayers, and we just want to make sure folks are taking that into consideration. So I would open it up for questions. Also, you heard today comments about letting kids stay through the end of the school year, defining what school year is. Many of our children and youth have extended school year programs. Is that included in that? So not only defining semester, but defining the school year, I think would also be important for us to be thinking about.
Thank you very much. I've got a question for you in terms of Medicaid. We have a number of our special ed students which are Medicaid qualifying, and we get reimbursement from Medicaid for those services. Would this continue to the age that we're talking about here?
You know, I don't have the answer for that, but I could get it for you.
Or, yeah.
Or maybe Becky would know, Becky Fredette. I'm not sure.
Where's our attorney back there? Okay. Caitlin, do you have any idea on that? Okay. Well, thank you. Are there other questions? Representative Woodcock?
Thank you, Chairman Ladd. Good morning once again, or good afternoon, actually. Just a quick question. You talked before 17, 18%, or Representative Ladd did, the number we generally assume for New Hampshire youngsters that are involved in special ed services. Do you have a breakdown, guesstimation, if you will, of the numbers that actually are in the 18 to 21 range of that percentage?
I don't have that information, but we can get it for you. Becky might know.
I'd
We
be,
may get that from them. I
yeah,
don't
that'd
know
be
if-
terrific if you could. Thank you, Representative Ladd. Thank you for the question.
Are
You're
there-
very welcome.
Representative Hobson, you have a question? No. Okay. Further questions? Thank you very much, Jane.
Thank you.
The next person is Maura Ryan.
Thank you, Chairman Ladd and Commission.
I don't know.
I supported HB 1513 as it was written. I know it was amended to what SB 394 is now. And as the federal language is age 21 inclusive, I believe we should support age 21 inclusive. I would also support going beyond that. As I had said in the 394 hearing in the Senate, the state of Minnesota goes up to age 26. Every child should be given every opportunity, and this is from the federal government, the US DOE, to complete a full-blown high school diploma, because that it basically leads to a path for better education. The federal district court that they're talking about in the Rhode Island case is the one that governs our area, because we are District 1. And if a kid with disabilities gets told they have to leave school with a high school diploma, I don't see why a normal student wouldn't be told the same. The child or guardian can choose to leave school at any time. That is the way it works. We've actually had situations where a parent has not filed for guardianship yet. Their kid turned 18 and the school came to the kid and said, you don't really want to come to school. You're not interested. Why don't you just sign out? Kid signs out. It's not reversible. It's not reversible. So we often tell parents, get the guardianship as soon as possible, and be very specific about education services. Adult services is not anything to really ascribe to, because once the student is done with school, and Michelle McKeon just wrote an article about this where she said keep your kid in school as long as possible, because adult services has no goals. It has no interaction with other people other than maybe going to the mall or going to the supermarket, and it has no way of pushing you further towards an independent living or employment. My son in particular has been registered with vocational rehab since the age of 14, and thus far he has not completed a single internship rotation. So I believe Attorney Bond also quoted in the 1513 hearing that 40 states went to age 21 inclusive, which is 22nd birthday. So I'm here to say that we will support age 21 inclusive. We will support beyond age 21 inclusive, but we will not accept less, because we know the federal government guaranteed us more. So we're here to support age 21 inclusive or more.
Thank you.
And also on the adequacy funding, the DOE had informed me that the adequacy funding is based off attendance on October 1st. So if the student is in attendance on October 1st, the school retains the funding for that year, regardless of whether the student moves out of the district or anything like that.
Thank you. Any questions? Not seeing, thank you very much. We're at the end of our pink card. We do have a technical assistance as needed from Rebecca Fredette. Rebecca?
I think Attorney Fenton had gotten some questions that she forwarded on to me regarding numbers. So currently we have 4 students who are age 21 in school right now. They will all be exiting at the end of the school year. We did have 20 students who started the school year at age 21, at age 20, and when they turned 21, they were exited at or before their birthday. So there's only 4 left that are beyond 21. We currently have 186 students who are age 20, and they, but unless I go through each individual student, I don't know who is going to continue on until past their 21st birthday, but there are 186 students. So the question was, how many students will this bill include if we use the 21 inclusive language? So theoretically, it could include those 186 students until their 22nd birthday. If this is the case, the cost at minimum, what we figure is a cost per pupil when we do special education aid. We work with Caitlin Davis's office to determine that number. Currently, the cost per pupil is $17,985.66. So if every single student were to continue, 186 students, and we're going to send you this, Diana has it to send to you, it would be right around $3.3 million at just the cost per pupil. If every one of those students went to the 3.5 times the cost per pupil that we provide for special education aid, it would be about 11 million. So those were numbers that were asked of me. Currently, the way the law is written, if anyone stays beyond 21, and even if you changed it to 22, we would not provide any special education aid or IDEA funding to those students because our state law would say up to 21. We do not provide it to students right now if they turn 21 and they stay in school for the remainder of that year because our law does say up to 21. And then, but if they did stay, it would be the same cost as I had listed for those other students. But those were questions that had been presented to me from somewhere here.
Okay, are there any questions, Representative Waltz?
So if we change this law to say that we're going to provide education through 22nd birthday, does that mean the funding will then follow from the state?
Yep. So if you change the law, I would be able to provide funding up until their 22nd birthday. And then if they went beyond their 22nd birthday, I would not be able to provide special education aid or IDEA funding.
Follow up?
Yes.
If we change the law to say the end of the school year of their 22nd birthday, would you be able to fund the full school year?
Yes, I would.
So whatever change we make here is going to be determining of your funding.
Yes.
Thank you.
Further questions? Thank you. So that closes, that's the last card, unless there's somebody else in the audience to speak on this bill. And so we will close 394. Yeah, hold on. Let's see what, who's 421? Both of them. Yeah. We have, yeah. How many cards do we have here for 420? 2?
Oh, gee, I didn't know that. Whoops.
Okay. Senator Waters.
We're doing 421.
I know it. No, we'd have to take it in the order, I guess.
Mr. Chairman, I may have to leave. I could, that's the warrant, introduce 421 for me. I think it's pretty straightforward when the time comes.
So, So what we could do is we could have 420 introduced, then we can recess it to follow 421. And 421, Grant, can you come forward and please introduce 420, and then we'll recess it immediately?
Absolutely.
And then you can let Senator Hennessy know what we did.
I will be very brief, but the Department of Education here is to back me up when you get back to 420. Good morning, Chairman Ladd, members of the committee. My name is Grant Bossy from the New Hampshire Senate, here to introduce Senate Bill 420 on behalf of Senator Aaron Hennessy, its prime sponsor. This bill establishes an ongoing extraordinary need education funding grant. This bill will allow additional funding to go to the neediest of our schools through the state based on the town's property equalized valuation per pupil eligible to receive free and reduced lunch. So let me just go through that formula again. You calculate the property equalized valuation for each town. You then divide it by the number of pupils eligible for free and reduced lunch. If that number is less than $1 million, you receive the full amount of the grant. You then get a sliding scale down. If it's more than $6 million per free and reduced lunch pupil, you do not receive a grant. This extraordinary need grant is set up as an ongoing grant in addition to the adequacy aid and the ongoing $35 million in relief aid we added in the budget last year. This bill would send additional funding to towns on top of what was accomplished in the budget, an additional $14.7 million for school year 2023. These grants are intended to provide consistency and stability for school districts. Therefore, they will not be limited to one-time use. Towns qualifying for this extraordinary need grant can be found in the fiscal note at the end of the bill. I would defer questions to the Department of Education, but if you have a question for Senator Hennessy, I'll make sure she gets you an answer. Thank you, and we ask for your support of Senate Bill 420.
Thank you very much. We will recess this particular hearing right now and come back to it following 421 at time to be announced. Welcome, Senator Waters.
Thank you so much, Mr. Chairman. Much
So we're
appreciated.
on to 421.
I'm Senator David Waters, District 4, introducing Senate Bill 421 relative to dual and concurrent enrollment for career and technical education center students. And if I may say as an aside, I had signed in support of 420 as well. I wanted you all to know there's bipartisan support coming out of the Senate for that bill. But 421 deals with our existing dual and concurrent enrollment program under RSA 188, a highly effective and strongly supported program that lets high school students take a couple of classes under dual and concurrent enrollment, save a lot of money, and give them a leg up on their career when they go on to community college or other higher education. The bill makes a couple of changes. The fund for this bill was transferred to over to the community college system, and so they're administrating it now. And under their current practices, they release funding at the time of student enrollment, which is what we do for adequacy grants, right? So it's kind of the same thing as that. There had been some concern from the Commissioner of Education that, well, if you got the money, you know, what will you really do to make sure the student stays enrolled and completes the course and so on? You know, I get that, you know, and I talked to Commissioner Ada Blue about it, and you know, it was also assured by community college system in New Hampshire they do a lot, and the high schools particularly do a lot, because that's where the courses are taught, to make sure the students are completing the courses. But nonetheless, we thought then down at the bottom of the bill, in paragraph enrollment, that this is language the commissioner thought would be a good way to deal with his concerns about when the funds are going out. So it says there's going to be an annual report on student enrollment, successful completion, grades of students in dual and concurrent enrollment courses, and that would be important to have, to see if there is an issue around whether students are completing or at a different rate that they might have otherwise. Now, the other part of this bill, Mr. Chairman, really kind of is in tandem to what we did in House Bill 1661. It's just, you know, these two bills came out of the study committee and our ongoing work on CTEs. I must say I'm a little jealous that House Bill 61 got a $35 million parking garage. So I want something on this too, all right?
Well, we can put anything you want on it.
Anyhow, well, maybe
Might be
maybe the CTE mobile vehicle can park at the new garage. Okay, so we'll be good. But the basic principle here is that we want, and you and I share this value, Mr. Chairman, others on the committee. We believe that career and technical education is fundamentally kind of a right for students in our state, and we want to make sure that every eligible student can enroll in career and technical education, no matter where they may be, because this is our future work force. It's opportunity for students and their aspirations. We had wanted to make sure that students who are not public school students had the opportunity to take career technical education. There has been an interpretation that because of the way the law is referenced, that those students who are in non-public schools could not take advantage of career and technical education. And I personally, with the Education Freedom Savings Account, we're going to have more students who are taking that option and going to, private schools. And I want the private schools are going to be offering the CTE programs, but we can, and we ought to make sure they can take those classes as well. So that's why you see it here. The governing body of the institution is, in the case of non-public schools, shall develop and adopt a policy permitting students residing in a district or in attendance of the non-public school or in grades 10, 11, 12 to participate in dual and concurrent enrollment programs. So just that reference there to governing body, not the school board, will open it up so that the students who are in those other schools are now going to be eligible to be in the dual and concurrent enrollment program. So I think it's pretty simple, Mr. Chairman, but there it is. And I know that we have both Beth Doran and Shannon Reed here to tag team on how this, what the program is, if you have more questions about that, and how this benefits the students.
Thank you very
Mr.
much,
Chairman.
Senator Waters. And before I open up to the committee, I do have one question. And the question is dealing with line 14 of the bill, where it says, or in attendance at the non-public school. We have a number of non-public schools, such as KUA Holderness School, where the students are not residents of this state. So should it read, or is a resident and in attendance at the non-public school?
Well, I see what you're getting at. I think that's best answered by Beth or Shannon. I mean, this wording is a little tricky, and I don't want to get ahead of myself.
I will ask that question.
Yeah.
Representative Porter.
Thank you, Mr. Chair, and thank you, Senator Waters.
Excuse me, if I just say, one of the problems, Representative, is that I think that or in attendance, if it's a student who's taking the Education Freedom Savings Account and they're not, they're going to another, the school happens to be outside the district. Anyways, we'll let them talk about it, but I just want to make sure we're being inclusive. So that, excuse me, I'm sorry.
That's
Representative
okay.
Porter.
That's fine. I know how minds work.
Or don't work, as the case may be. Go ahead.
You said that, Senator. I didn't say that. Can the state tell a non-public school or private school that they have to do something?
No, but it can certainly tell them there's a great opportunity for their students.
But the bill says it shall develop and adopt a policy permitting students to be dual and concurrent.
Well, I'm sorry, I misanswered that. I think that, if we're offering this and schools want to take advantage of it, they ought to have a policy for that opportunity. So, yeah.
Are there further questions of Senator Waters? Thank you for hanging loose so long with us.
Well, I appreciate your indulgence, Mr. Chairman.
Thank you.
Obviously I'll be available for questions that may come up later in the hearing, but thank you
Great,
again.
thanks. Okay, go back to the pink cards here. Beth, were you wanting to speak today too? Or Shannon, together, both of you? There are the cards over there. You're both representing community college system.
We are. Thank you for
Welcome.
having us. I guess I should say good afternoon. I think my testimony was probably written as good morning. Thank you for the opportunity to come and talk about Senate Bill 421. I want to provide just a very brief bit of background on these programs. A number of years ago, the community college system created dual and concurrent enrollment programs in New Hampshire, the largest of which is called the Running Start program, which is a program where high school students take courses at their high school during their school day, excuse me, taught by their high school teachers who are acting really in partnership with a college faculty member to teach that course. And the student gets high school credit and the student gets college credit for that course. It's a very successful program. It enrolls about 8,000 students every year who take one or more of these dual credit courses, gives students a real running start on their college education in a way that is accessible to them and affordable, and it covers a real range of disciplines. In addition to Running Start, we also offer a program called Early College, which is similar in that it confers both high school and college credit, but in early college, students will actually go to the college campus and take a course. So there's a sort of a nuance difference between those two. And then there's also eStart, which is similar, but the courses are taken online in partnership with a virtual VLAX, Virtual Learning Academy. So those are the three different kinds of dual and concurrent enrollment programs offered through the community colleges here in New Hampshire. About 4 years ago, a scholarship fund was created. It was established and created to support dual and concurrent enrollment in STEM and STEM-related courses. And this is the subject actually of 421, not the courses writ large, but this funding opportunity for STEM and STEM-related courses. And then 2 years ago, CTE courses were added to that grouping of courses that could be supported through this scholarship funding. So initially in this program, the funding ran through the Department of Education, and at the end of every semester, the community colleges would inform the DOE the number of students who participated, and the DOE would essentially remit the funding to the community college system to cover the cost of their enrollment. In the last budget, the department came in and indicated that it was no longer able to fill that role, and they had left the program out of their budget, citing administrative burdens of the program. The House Finance Committee, really wanting this program to move forward, and Representative Vlad was involved in that effort as well, asked the community colleges if we would then administer the program so it could remain an opportunity for New Hampshire students. We said we would. So we have been administering the program since then. So the funding then comes directly to the community college, and we essentially account for it based on student participation at the end of a given semester. Does that more or less make sense? Okay, so Senate Bill 421 really relates to the funding program for those STEM-related, and CTE courses. And as Senator Waters noted, it makes two tweaks, really, to the program, which we see as serving the interests of fairness and process improvement. So the first change is really the process improvement change, and that is that the payment would be triggered upon the student starting the course, not upon successful completion of the course. That aligns with payment practices generally for our colleges, and I think probably most educational organizations. And it streamlines the administration for us because we can do that at the beginning and don't have to kind of catch up at the end with where you may have a variety of different outcomes. And then the second change just adds those non-public schools that currently have a Running Start in them, for example, but for purpose of this funding program, don't really fit within the language of the program as it is currently written. So right now, for a school to have its students eligible for the funding, the school or the school board or the school district needs to enter into an agreement with the community college system that basically just outlines how this all works. But because the language of the program says the school board of each school district, then that really leaves out schools like Trinity High School in Manchester, Bishop Brady here in Concord, schools that are very much part of the ecosystem of New Hampshire's communities and where students go, but are just left out of the language of this bill. Of the current program. So that is what the bill does. The Senate amended it to add the annual report, which we think is certainly a reasonable request, so that we will report student performance metrics on an annual basis to the Department of Education. So that's essentially the outline, and this is really in the context of a program, Running Start, that's been around for just about 20 years, has steadily evolved in all that time, and really grown very, very well and very effectively for New Hampshire students and families. And we will be happy to answer any questions that you have about the bill or the program. And before I turn it over for questions, though, I'd like to just ask my colleague Beth Doran, who runs this program and runs our college access programs generally, if I've left anything out that she'd like to add or clarify.
No, you have not left anything out. That's very comprehensive.
Thank you. Representative Tanner.
Thank you for taking my question. If my memory serves me correct, in order for the college course to be taught at the high school level, the teacher has to have certain requirements. And I'm wondering how that's going to work in some of these non-public schools, like perhaps Prenda or Chi, which are micro schools that don't have certified teachers, or in any, how are they held to the same standard?
They would need to be held to the same standard, mostly because in order to maintain the integrity of the program, the high school teachers need to have the same requirements as our adjunct faculty. So that's an area where we really try to stick with exactly what is required of anybody teaching a college course within the community college system.
I might add that that's one of the reasons why we put in the National Alliance for Concurrent Enrollment program. That is a program which addresses all those issues that you're thinking of. So the standards are high. They must be the same as offered by the university itself or the community college system itself.
Exactly.
Yeah, with their accreditation process. Representative Woodcock.
Thank you, Chairman Ladd. You may know the answer. I have forgotten. I'm sure they know the answer. Homeschool youngsters, how do they participate in this program?
They would not necessarily participate in Running Start unless they're attending the high school for a course or two, but they have the opportunity to participate in any of our early college courses on the college campus or our eStart courses. And honestly, a good portion of our early college courses where students come to take the courses on campus, as well as eStart, are homeschooled students.
Thank you, Chairman Ladd.
You're welcome.
Thank you.
Are there any schools, community college system level schools, that are beyond the community college? Is the university system, or is SNU getting involved with this process at all? Do you know of?
I know at various points there have been other colleges and universities that have offered dual credit options. They're not as comprehensive as what the community colleges, as that partnership with New Hampshire high schools, and I don't know if they're still currently doing that. But dual and concurrent enrollment, as you know, has sort of taken off nationally. I think it's probably in just about every state in one form or another. The University of New Hampshire, I had a couple courses that they were offering for dual enrollment, but really this is writ large, this is a program of the community college system.
And my question, Shannon, is, are they also chasing the scholarship money? Are they, they go in, they get that, what, 150, wherever you are, $200?
The scholarship program is only for dual and concurrent enrollment courses taken in partnership with the community colleges.
With the community, good. Okay. Representative Luno.
Thank you very much, Mr. Chair, and thanks very much, Beth and Shannon, for joining us this afternoon. Sort of a technical question based on what Senator Waters was saying, and he was saying how the language change down on lines 12 through 14, very, very specific to, I think, include, as you say, Shannon, schools like Bishop Brady and Trinity. But I'm just wondering, how do those changes made in Section 2 translate into students from, let's say, Bishop Brady, being able to participate in dual and concurrent enrollment programs as laid out in section 1.
In that instance, they already do. There are already those courses offered there, but they don't have access to the funding for them.
So that's what I'm talking about. So let's just and follow up, Mr. Chair. So in looking at section 2, let's just say Bishop Brady, the governing body, Bishop Brady, develops a policy. So now the student at Bishop Brady in grades 10, 11, and 12 can participate in dual or concurrent enrollment programs. Now let's go up to section 1. And I'm just reading from lines 3 and 4, which is established at $150 per course, to the CCSNH institution where a high school or a CTE student enrolls in a concurrent enrollment class. High school is defined in the statute as being just pull it up here. 194.23, the term high school shall mean a public school or public academy comprising, and it gets into grade spans. So I'm just wondering how this, I mean, it's clear the intent, and I agree on the intent. I'm just stuck on the, on how it passes through the various sort of filters in section 1, where you've got to be attending a high school or CTE.
I would say that's a very good question, and one that we should take up with potentially with legislative drafting.
Yeah. Okay. Thanks.
That had not come up before as a question.
And in all fairness, I don't know if the definition of high school in 194.23 applies to this section or not, but it doesn't say that it's limited to the section that it's in.
There's a number of references throughout statute.
We've got
there.
this all over the place. Yeah.
My question though is that I asked Senator Waters this. You have a student at Holderness School or Kimball Union, which is a non-public school that does not reside in this state. But the way that's written, I'm not so sure now that they couldn't say, hey, we want to get that $150 for this kid to participate in this concurrent enrollment program.
You're absolutely right. However, at this point, they don't offer any of those courses, but they could.
Yeah.
But we would support, I think Senator Waters mentioned a New Hampshire resident. I mean, that I think would make a lot of sense.
Thank you. Shannon, you agree? Okay. Any other questions of the community college system? Yes, Representative Cornell.
Thank you. I just want to say thank you. I think it's a great program, and I'm sorry I missed you this morning, Beth, but my chair called a meeting at the same time as our advisory CTE committee this morning, so I missed it.
Well, that's it. Good. Okay, are there any further questions of the community college system? Not seeing any. Thank you very much.
Thank you all.
Thank you.
Are there any other folks who want to testify on this bill? Then we'll close 421. And let's return quickly to 420 so we won't have to come back to it, after lunch. Caitlin, you had signed up as a TA if needed.
Correct. So I'm here if needed.
Okay, let's go back to 420.
Just real quick, does the committee have the fiscal note attached? No. Okay. So the one that was on the table, I noticed for some reason didn't have the fiscal note. The department did provide the fiscal note to the Senate in December. So I have copies of that to pass around.
Do we need more pink cards here?
Oh, already? Okay.
Representative Porter? Well, let's make sure everybody's sitting down here and ready to go. Okay, you ready? Okay, go ahead.
Thank you, Mr. Chair. So if I read the bill right, or understood what Mr. Bossy said previous, this is an ongoing grant,
Correct.
and so it will be included in the budget and in future budgets,
Correct.
and the money will come from
The Education Trust Fund.
the Education Trust Fund.
Correct.
What if there's not enough money?
If the Education Trust Fund doesn't have enough revenue to pay for all the expenditures, it's subsidized by the general fund. There has been many times in the past, there has not been enough funding in the Education Trust Fund in the past, and the general fund has subsidized it. In the last several years, the Education Trust Fund, the revenues have done very well.
Yes.
And therefore, as a result, we have not needed a transfer, but the assumption of that transfer would cover this.
Can I have further?
Yes.
I don't mean to be what they call a Debbie Downer, but we have been through times where I'm sorry, I'll be a Margie Downer then. There have been times in the recent past where the revenues right now we're doing very well, but there have been times when revenues are very low, and it's caused the budget to eliminate other sources of revenue to towns and cities and school districts that they had been giving prior. But that's not going to happen with this. This is permanent till the day I die.
Nothing is permanent. Actually, the people that have the ability to make something not permanent sit in this room. As of right now, the way this is written, it would be an ongoing grant that would continue on. If there was not enough revenue to cover the adequate education. So one thing is this is putting it into the adequate education grants, which is a part of the formula. The first part is the statutory piece that we are constitutionally required to provide. And then there's several other grants that is in the adequate education funding formula. The fiscal capacity grants, this extraordinary need grant, and the stabilization grant. Those are the other three pieces of that. That entire amount equals adequate education grant, and then we are statutorily required to pay for that entire amount, regardless of the revenue and regardless of the appropriation. So if there's not enough appropriation to pay for it, we also are able to draw a warrant and pay that that obligation.
Okay, so the state also promised large portions of the rooms and meals taxes to communities, like 40% originally was the thing that wasn't going to go away, and we haven't been able to do that in many, many, many years, if ever, because it was always it's changed in the budget process. Would this be changeable in the budget process? I guess what I'm saying is, if we're going to say to towns and cities, you're going to get this forever, and they're thinking they're going to get it forever, and they may plan their budgets on getting it forever, and then suddenly it's not there anymore, that's going to be an increased burden on property taxes or cause schools to have to do what they have to do to cut their programs. So I'm just trying to find out, is this forever?
That question actually should be to your colleagues in this room, not myself. I do want to say in the 13 years I've been at the Department of Education, so through 7 biennium budgets, the adequate education funding formula and the grants associated with that have been changed in almost every single biennium budget process, and sometimes outside that process. So it would not be atypical for a change to be made either to increase or decrease amounts of grants in the formula.
Yes, Margie, finance can take it away.
Yes. Absolutely. Representative Woodcock?
Thank you, Chairman Ladd. Could you give me the layman's explanation? That's all I need. Of 2 towns on your chart. Alexandria and Alton.
So the reason being that Alexandria and Alton wouldn't receive any additional grants is because, let's see, let me look at the calculation.
Well, I didn't hear what them particularly, just I was using that from money to no money and no money to no money.
Right. So the formula requires you to have a $6 million of equalized valuation per free and reduced lunch student in the town.
Okay.
So I'm going to look up, of course, my computer has now locked itself. So Alton, for example, has a $16 million equalized valuation per free and reduced lunch resident in the town. So they would not be eligible for a grant,
In either year.
either year.
Okay.
Correct.
And
And
Alexandria?
I do want to point out that either year, very much an estimate. 23 is an estimate. 24 is even more of an estimate because
Okay, that's okay. I'm just trying to figure out.
and so Alexandria is estimated to have an equalized valuation of $5.9 million, or yeah, $5.9 million in fiscal year 23 per student, and in 24. And in 24, Alexandria is estimated to have an $8.1 million. Therefore, would not be eligible to receive the grant because it's over $6 million
Over $6
per
million.
student. Now, I do want to point out two things because you see obviously a substantially lower amount in 22 than you would receive, sorry, in 23 than you do in
Okay.
24. And the reason being here is because 23, there is a free and reduced lunch hold harmless in the formula. And in 24, as of right now, that has not been amended in the budget. So as we, maybe just to jog people's memories, because it's been a little bit since we've had an adequacy hearing in this room, the Department of Agriculture had waivers for free and reduced lunch meals. And then as a result, school districts have had challenges receiving the applications back. As such, in fiscal year 2022 of the budget, in House Bill 2, it allowed us to use the previous years, sorry, 2 previous years, like prior to the pandemics, free and reduced lunch numbers. So that hold harmless was in for 22. In 23, there's a similar hold harmless, which had us look at the pre-pandemic ratio of free and reduced lunch kids in a school district and use that ratio to apply to the current enrollment. So if you had 25% free and reduced lunch kids before the pandemic, and then during the pandemic you only have 18%, we actually use that 25% in 23. So you're seeing that number coming through in the 23 number, which is driving a higher grant amount. In 24 for the estimate, we use the actual free and reduced lunch numbers because as of right now, that 23 hold harmless expires in the in HB2.
Okay.
I know that was not a super layman's
Yeah, thank you.
term,
I
but-
appreciate the detail on my layman's term. I hate to have the detail, but no, thank you, Caitlin. Appreciate it.
Representative Cornell?
Thank you. Thank you for taking my question. Instead of using the whole harmless free and reduced lunch, did you think of using the Medicaid number like we changed one of the other bills?
So I believe there is a bill that's working its way through the legislature. I think the hearing is tomorrow morning to potentially do that. That likely will go into effect. I believe it's in fiscal year 24. That does require us right now. That bill is actually only requiring us to submit an application to the U.S. Department of Education. We then have to be selected. So I'm not sure if we're going to be selected for that, but we will be working through that process.
If that happens, you'd use that number for this too.
So if that happens, those kids that are Medicaid eligible right now become automatically eligible for free and reduced lunch. So it would have a higher free and reduced lunch number in that formula, including those Medicaid kids. Right now, the free and reduced lunch number only includes kids whose parents have either filled out the application or participating in SNAP, WIC, TNF, or are a foster care child.
Representative Tanner?
Thank you. How does this apply to charter schools?
It does not apply to charter schools.
Okay, thank you.
You good? Okay. Further questions? Representative Luno?
Thank you, Mr. Chair. Actually, could I make just sort of a comment?
Sure.
I know this isn't deliberation here.
Well, what we have here, we have an early bill here.
Yeah, yeah.
And we're gonna have to maximize on, all our time on this bill. This right here is information which has amendments for this bill, which I was gonna speak to after all this.
And that's good, and I think my comments sort of, I haven't seen these amendments, but I think my comments sort of go along the lines of this. I'm looking particularly at Manchester, because it clearly gets almost nearly $4 million in the first year of this, which is not an insignificant amount of money. And for the Manchester School District, I think every penny counts. But to put that in context, when you've got about $4 million and you're educating approximately 13,000 students, this comes out to about $300 per student in increased state grant support. And I want to sort of juxtapose that with what the School Funding Commission found last year, which is Manchester spends about the least, or budgets about the least amount per student for public education, just a little over $12.6 thousand. So $12,000 per student. The state average is certainly a lot higher than that. And for Manchester, at least based on our expert analysis, in order for Manchester's average student to perform at state average, would cost closer to $21,000 per student. So up from $12,000 to $21,000. $300 puts us in the right direction, but it doesn't really move the needle. And I hope that I hope that this committee will be able to recommend amendments that do start to move the needle. Maybe not as far as a redesigned funding plan, and we do have an interim study to look at that. But I think given what we've certainly heard on this bill and on other bills, with state revenues where they are, that we do something to move the needle for our school districts, but in particular districts like Manchester and Newport. Thank you.
Are there further questions? Representative
Very,
Porter?
very quickly, thank you. This money that comes in is not limited to, it can be used for anything within the district, is that right?
Correct.
Further questions? Thank you, Caitlin. I'm just debating whether I should go do a pink card to hand all this stuff out. But I do have some concerns. This bill was given to us. It came to our committee on not this past Friday, but the Friday past that. So we've had it about a week. It came in and we recognized it was an early bill, and we had about 3 days to get it scheduled so we could have a hearing and exec it and get it out by the 14th, really basically by the 13th, which is Wednesday. And so in looking at it, it has a lot of financial repercussions and possibilities in terms of our working on. And I have some materials here, and I think what I'll do is I'll fill a pink card out so I can present this stuff and discuss it, because we're just running out of time here, unfortunately. So let me fill out one of these pink cards here, or at least do it.
Mr. Chairman.
Yeah.
Mr. Chairman Ladd, I'm not trying to be troublesome at all, but if this is the policy committee and the finance is the finance committee, is this relevant to our committee? And I don't know the answer to that. That's an honest question.
So, for the record, my name is Rick Ladd. I am a representative from Haverhill, New Hampshire here, and I'm here to speak on 420. 420 is a bill which deals with trying to move the needle here in terms of our supporting school districts. And I have some information which I'd like to provide regarding how we're doing that in the same section of law. So I'm going to pass these materials out, and I'm passing them out for the simple reason that you might want to look at them and they can be considered when we exec on Wednesday. But rather than making them available on the web, we can discuss them now if you so desire. So what I'll do is I'll hand out these amendments and the supported materials so you'll have them available. And maybe if Representative Ford, you might help me or somebody in distributing the materials. That goes to everybody. Also, members of the public should be afforded the same. Pardon me? That can go out to everybody? This can go? That can go?
Okay, you need quite a few.
Here's another amendment.
Oliver's there.
Another one? Nose. Okay. Pardon me? I'm trying, I think I'm missing one myself. You should have 3 different amendments, 1380, 84, and there's one other which I don't have. That's 84, 1384, no? 81. Okay, those are extras, so they can be handed out. And all the materials which are handed out could also go to those that are sitting behind me. Does anybody have copies of 1381? I might have it up there. Yeah.
These are all extra.
Okay, I'd like to go ahead if. Yeah, that's what I was going to do right now. Okay, everybody should have this sheet right here, which is from the Education Commission on the States. It's regarding special education. So you should have that form. You should also have a form that looks sort of like this. which is dealing, it says at the top, a proposed funding adjustment for special education differentiated aid. Okay, you should also have a sheet that has a table on it with some figures on it regarding most of your towns. Just one side. You should also have a sheet that looks like this, which shows the number of handicapping conditions that are reported by each district to the State Department of Education. Okay, you should also have 3 amendments, 1384, 1381, and 1380, going downhill. Okay. Those are there was another sheet that says other handicapping. I don't think you have that. You don't need that. That's not part of it. Okay, what I've done is I've looked at the education funding bill, which we had presented to us by Senator Hennessy's office and sponsors of that bill. We've seen that bill before, or that concept before, many a time, dealing with the ratcheting down from the $6 million mark down to the lower property valuations in terms of funding students. We have seen this before originally came out of the task force back in that Karen Umberger had back in 2018, I believe it was. I'm concerned that we're looking at grants today out in the public schools. One of the areas that I'm very concerned about, have been concerned about for years, is the funding of differentiated aid for special education and how that impacts policy-wise in the districts. We have one way of doing it right now. Actually, we have a hybrid. If you were looking at the sheet that I gave you from the Education Commission in the states, that sheet shows you how various states fund special education. There's some different models in there. Some give varying level of weighted funding for various categories of special education. We have 13 categories that are reported. You'll see that on the sheet right here. I just grabbed one of my, I could have grabbed 2020, I grabbed 2019 and made a copy of that. They all report the same 13 type categories, and it shows the number of students that are in these categories throughout the state, the numbers. And our number comes up total special education handicapping areas, IEPs, a little over 30,000 kids in 2019. It's very similar for 2020, and if you went back 10, 12 years, it was right around 29,000. We're in the same ballpark. We haven't diverged a whole lot from that, even though our demographic has gone down in terms of our students, total student population. We've seen that special ed service area pretty much as a constant with the 30,000 mark. So that shows you the various categories right there, starting with autism and then going down to visual impairments. My experience as a school principal and administrator have been that there are a number of handicapping conditions out there in our schools which take a lot more support, a lot more time, and a lot more funding to support than others. And we all know that there's some students that might receive special education IEP support in the area of speech pathology, speech services, therapy, which may only amount to a half hour a week. But we also know that there's some other students which require a whole lot more development in terms of speech that could be a lot longer than that. But the majority are not as long as a student that might have autism, or a student that might be TBI, or a student that might have an orthopedic handicap, which is more costly and requires a lot more time often than the student that's receiving speech services in the lower elementary grades especially, and trying to start developing their articulation the way that we'd like to see the child be at. So the costs different. They're different from one handicapping area to another. You can see that in some of the sheets that come from various states on the Education Commission in the states. They may have at least 6 or 7 different categories in some cases. We have a hybrid in this state. We have one funding amount for differentiated aid in special education. That's $2,000+. There's a sheet which I have that I made for you that shows that. It's this sheet right here. And you can see that, our base cost is identified, but the special ed cost for students is $2,037.11. That's projected for FY23. That's our estimated cost for FY23. That's the amount which we'll be using in the funding, is every student that has an IEP will receive that type of dollar. We also have a hybrid model in the state where we do fund those students which have a handicapping condition which requires more than 3.5 times the base cost, up to 80% to 10 times, and then it's funded fully. That's a hybrid model, so we have two ways of funding special education in this state, whereas many other states have, prior to getting to that hybrid model, the heavy weighted amount for the student is in the CAT aid category. There's other differing weights provided. I'm trying to look at and trying to break that out somehow, and it's very difficult in this state, seeing that the material, even though it's provided by the individual school districts, on this district-wide basis in reported DOE, and you can see that on the forms which I provided you, on the areas of 1 through 3 in category A, you'll see developmental delays, specific learning disabilities, speech or language impairments. That's an area which, generally speaking, does not cost as much as those 10 areas down below. So what I'm proposing is that we address the 3 areas in category A, funding them the way they're being funded currently in differentiated aid. However, recognizing that the costs associated with the group's areas in category B will cost more and do cost more. So in category B, or category A, if you look at our total amount we do for base adequacy, the amount of money we provide out of base adequacy for the differentiated aid right now is about 54% of the base cost, or $2,037.11. I'm proposing for the areas in category B, autism down through traumatic brain injury and visual impairments, the cost would be 89% of the base, or $3,367.08. That's approximately $500 more than what we're doing right now. In translating that to what the total costs we'd be adding into our budget, it comes out to exactly the same amount of money that the educational extraordinary needs grant would require, 14 point something million. This increases our budget by another 14 point something million. If we follow through and do it with the 2 categories, A and B. If we don't have that information, and in my communication with the department, it can be gotten, then we could fund at a different level and raise the amount of money which we're funding for differentiated aid by funding at like a 0.67% of the base. If in funding at 0.67, you can see how that would stack up in regard to what your districts are getting right now. For example, Litchfield, which has 227.08 students qualifying for special education, the current funding formula provides $462,000 some odd dollars to that district. This funding formula would provide $576,000. And you can go down and wade through and see how it affects the various districts in this room. So what I'm proposing, this is one amendment that you will see, is I'm trying to increase the funding for differentiated aid special education based upon 2 categories. It actually only increases those IEPs or those handicapping conditions in category B. Everything else just remains the same it is in those other 3 IEP areas in category A. The second thing I'm adding in as an amendment is that when we have grant monies, See, the differentiated aid right here is a part of the constitutional requirement. Your base cost and your differentiated aid are constitutionally required. Every student gets the same amount of money, regardless of the wealth of the community or the poverty of the community. When we start talking grant money and stabilization, you start going outside that constitutional requirement, and you get into the fact that now a district that maybe doesn't have the high property values is entitled to some fiscal capacity disparity aid, or you're entitled to a extraordinary grant need grant program. That can change. However, the differentiated aid goes up. It doesn't get wiped out. It's part of the formula for the constitutional requirement, which we have a Conval case right in front of us right now, which we should all be aware of and we need to be looking at. When I was on the funding commission for the last year and a half, that was roughly about a year and a half ago, Dave, I can remember we discussed this and I had concerns. I said, I like the idea of funding special education and using weights. I'm not necessarily supportive, though, of funding special ed at one increased total weight, and I understand that there's a lot more to the whole funding formula, at a level of 4.29 times that $6,501. I am supportive, though, and do recognize that our policy right now, as we have it, does not recognize, and the funding that follows our policy, that we're not properly funding all special ed the way we should in our state. And I'd like to propose that we look at that in terms of that First Amendment. The Second Amendment, though, I have, and I was just about ready to speak to, deals with accountability for the grant. You can write in accountability to districts for grant money. If you're going to receive these grants, there's some accountability you have to ensure that your program that you're going to use to try and see this achievement and growth is approved by the Department of Education. And you can be required also to submit annual reports showing that you are demonstrating some growth or some gain for the areas that you're identifying or receiving that grant money in. None of that grant money, none of the money provided has to be targeted. That's the point, targeted towards a specific area within our funding formula. My intent in the Second Amendment is that there be some accountability for the Education Needs Grant Program. You can see that in that amendment. That amending language is an exact extrapolation from the report that came out in 2018 from the Umberger study. The last amendment is an amendment which would combine both the first two amendments into one, if in case this were to move forward. I'm presenting it primarily because I want to open up the policy discussion regarding where special education is going. Special education, as I alluded to at the very beginning of the meeting, we had about 30,000 kids in that program right now. Our demographics going down, our special education's basically not. And the costs are increasing all the time. And yet we know we have to provide these children the services they deserve. When I talked to the superintendent of schools in my district, I asked the other day, about roughly 5 days ago, where are we going with special education services? She responded to me that the other health impaired category is going off the charts in SAU 23. A lot of it's a result of the pandemic and kids not having the opportunity to be eyeball to eyeball with their teacher and developing a number of health impairments associated with what they have gone through. They've been traumatized. So in conclusion, I offer these materials for you to consider, to think about, and when we come back on Wednesday, we can address it further in that formal process. Thank you.
Representative Luno.
Thanks very much, Representative Cordelli, Mr. Chair, and thank you, Rick, for bringing these forward. And I think we'll probably have a very robust discussion on these on Wednesday for sure. And I think this is certainly an area that deserves robust discussion. One of the things that I liked about Senate Bill 420 as it was brought to us is, something, it's at least something. But it does it in a way that it applies that $14 million using essentially two factors: access to resources and poverty. And so it does it through that somewhat complex formula of equalized valuation divided by the number of students that are enrolled in free and reduced price lunch program. So I think it's a very interesting approach, and it addresses through that $14 million using those two very important factors. I've only really had a chance to look at your amendment 1380, as I think you spoke to sort of that in greater detail, and what my I guess only criticism on 1380 is that it fails to, while it certainly looks at, it doesn't look at poverty so much as it looks at costs associated with special education, but it fails to consider the access to resources. And you can see that's borne out in your in the spreadsheet that you did with the towns that I think several of us represent. And I want to pick on Manchester again, because I like picking on Manchester because it's clearly a standout in the state in a number of different ways. But what 420 as introduced to us does for Manchester is increases the state grant to Manchester by almost $4 million in the first year. What Amendment 1380 does for Manchester is increases Manchester's grant in the first year by only $1.3 million, not by $4 million. And that's, that's shown, that's the difference between the $6.3 million as calculated in the amendment minus the $5 million that it currently gets under the special education portion of its adequate education grant. So it's only a $1.3 million increase. And that's happening because access to resources is not being considered in Amendment 1380. So that in fact every school district that has even one special education student is going to be getting an increased grant from the state, whether they need it or not. Newcastle's going to get an increase, whether they need it or not. And I think in here in New Hampshire, where we have failed to provide adequate funding, tends to be in the districts that don't have access to the resources they need. And I have to applaud you, Rick, because we're all trying to work on ways to improve education funding. But 420, as Senator Hennessy has brought it, doesn't put a lot of money onto it, but it is directing it to where it's needed most. And there's you've put a lot of material here on this, and you've worked. I mean, this is a lot of work, Rick, and we don't have a lot of time to get through it. But I'm looking forward to working through the other amendments that you've brought forward as well. But I just hope members of this committee will consider, that $14 million, and this goes right to Mary Beth's question. This is a policy question. It's not the total amount of money, but it's how it's being used. And I hope members of this committee will look to directing it to where it's needed most as being a policy goal.
Thank
There's
you.
No question in there.
Yeah, I know there's no question there, and it's more informational. What I'm trying to provide here is that it is policy to me in the fact that we're recognizing under differentiated aid that special education services are an area that every child deserves support in. Every child. And if you go back to the Claremont decision, I believe it's back in 1994 thereabouts, one of the first ones which we had there. If you look in law, it also addresses this issue that we are required to provide this type of support for all students, and followed up by the Londonderry decision a little later that poverty and wealth of the community should not impact what we believe is a necessary service. And the only way we're going to get a service is so we can afford to provide the service. So in order to make sure your policy is followed out, and so I can't divorce costing and policy from each other, they're both very related. And if we're going to be providing these very costly services, today we've spoken about a lot of special ed areas, and we are talking about services which are off the charts in terms of school districts being able to provide. This right here is this amendment that I'm bringing forward is not subtracting from what has been done in terms of directing poverty money to areas that have the poverty, the $14+ million that Senator Hennessy's brought forward. It's adding to it and saying, yes, we are all going to add another 14 million. So it comes out roughly around $30 million to our funding for education to support the policies that we need to be conducting or administering and following through on in special education. And we have these 13 categorical areas right here. We know that they cost more than what we're providing. The funding commission saw that. In fact, the idea was to weight it at 4.29. I'm waiting here at what, 0.8 something of the base? Which is a significant amount that's less, but it's working to provide that support for all children. Now, if you look at the vote that came out of the Senate in 420, there was one vote which was oppositional to it. The reason why? There's nothing in it for my towns. The money that's going out in 420 is for poverty areas, right? The senator that spoke out said, and spoke out quite eloquently, is that, yes, it's good, but it doesn't provide anything for my community. And I'm looking for their students in every one of these communities, in every them, whether you're from Tuftonboro or you're from Haverhill, two very different, or Hopkinton, very different communities in terms of assessed property values and being able to provide the funds needed to support their programs. I believe that every student deserves that opportunity regardless, as the court case said, regardless of your wealth or your poverty. And that's why I've also decided perhaps we need to be looking at differentiated aid. It's an area which we haven't touched since I've been in the House, and that's 14 years. It's time to really be analyzing. Yeah, we have a COLA. We increase it somewhat, but we haven't made a significant change at all to it. And yet we know that we're not able to provide all these services without taking money out of other areas of our operational budgets in the districts. That is occurring to support special ed. So that's why I bring it forward, so we can have an honest discussion, look at it. You know, I can go any way on this. This does, however, I think it's time that as an education committee, we have this discussion as a whole.
Mr. Chair, did you want to continue with questions now, or let us chew on this until our session on Wednesday and delve deeper?
It's a lot past lunch. I don't think we should be taking a whole lot more time today.
Real quick question, Rick.
Okay.
Yeah. Thanks. So do these amendments build on each other?
No.
All right,
No,
so-
well, one does. The final one includes, there's two amendments. One has grant accountability in it.
Okay.
That's the one that comes out of that previous task force.
Yep.
And then the other one deals with the special education additional aid. It speaks to, it's a simple amendment which adds in under differentiated aid 2 brackets, category A, category B, and it sets the funding amount for category A and category B. The funding, those IEP conditions listed there are the same conditions which are used by the department, and you're having to respond to the department as a district, how many kids are in each one of those categorical areas. So there's nothing changed there from what we're doing. It's primarily a change in terms of how we're funding, as Mary Beth said, how we're funding the question at the beginning, and costing out these services for special education.
So is it a possibility that someone would support all three amendments?
It's possible.
But yeah, that's.
It's possible. Yeah, you could. The amendments. The last amendment would be just amending the bill with everything that we talked about.
Right.
So Amendment 1384 combines Senate Bill 1420 with Amendment 1380 and 81.
That's correct. Yep. It's like the senator used to be that was here, or Senate representative used to be on the from where that had always a stack of amendments sitting beside him when they were in exec session, and that one didn't work, so I'll go to this one, and finally work through their amendments. Yep.
Another quick question, or do you want to hold that till Wednesday? Okay.
Technically, the hearing is still open for anybody that's here.
Yeah.
Thank you. I don't know how quick this will be. We are talking about, thank you for taking my question. We are talking about grant money that is being provided by the state, or is this federal grant money that is coming into the state?
We're talking about money that's appropriated by the state of New Hampshire.
Okay. Thank you.
So I guess we will end the hearing on 420 today and have a little bit of review to do for Wednesday, and should be an interesting morning on Wednesday. So thank you very much, all.